Well, good morning, everyone. Welcome to the fifth hearing of Portfolio Committee Number 1, Premier and Finance, for the inquiry into budget estimates 2025-2026. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the lands on which we are meeting today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name is Jeremy Buckingham and I'm the chair of the committee. I welcome Minister Cotsis and accompanying officials to the hearing. Today the committee will examine the proposed expenditure for the portfolios of industrial relations and work health and safety. I ask everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. Welcome and thank you for making the time to give evidence. All witnesses will be sworn prior to giving evidence. Minister, I remind you that you do not need to be sworn as you've already sworn an oath to your office as a Member of Parliament. Mr Draper, Ms Dobbins and Ms Campbell, I will also remind you that you have already been sworn before this committee during this inquiry and do not need to be sworn again. For all other witnesses, could you please state your name and position title and swear either an oath or affirmation? And I'll begin with Mr Wesling on my left.
Thank you. Good morning. My name is Tony Wesling. I'm the Group Executive of Workers' Compensation at iCare. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Ms Applin.
Good morning. Janina Applin, CEO at iCare. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you. Dr Casey.
Good morning, Patrina Casey, Executive Director, Strategic and Corporate Services at SafeWork New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Ms Shora.
Good morning. Janet Scorer, the SafeWork Commissioner. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you. Mr Head.
Graham Head, Secretary of the Department of Customer Service. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Ms Rizzo.
Good morning. I'm Marina Rizzo, Executive Director, Industrial Relations at the Premier's Department. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you. And Ms Nagel.
Good morning. Lauren Nagel, the Executive Director of the Long Service Corporation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Thank you all. Today's hearing will be conducted from 9:15am to 5:30pm. We're joined by the Minister for the morning session from 9:15am to 1pm with a 15-minute break at 11am. In the afternoon, we will hear from departmental witnesses from 2pm to 5:30pm with a 15-minute break. During these sessions, there will be questions from the opposition and crossbench members only, and then 15 minutes allocated for government questions at 10:45am, 12:45pm and 5:15pm. We'll begin with questions from the opposition. Mr Tudorhope.
Good morning. Morning, Minister.
Good morning.
All the officials, this big array. Well, it's a good omen this morning, Minister. I'll get it on Hansard already. My daughter had a baby girl yesterday.
Yay!
And she called her Sophia.
Now, you know that in Greek that means wisdom.
I'm sure that's right.
Sophia.
Joining the Labor Party?
So there ends the niceties.
We're always nice.
Minister, are you proposing to amend Section 140 of the Workers' Compensation Act?
Section 140 of the Workers' Comp. Sorry?
Are you proposing to amend Section 140 of the Workers' Compensation Act?
What do you mean?
Well, let me give you some context, Minister. You'd be aware that in February 2025, this year, workers' compensation nominal insurer was successful in the New South Wales Court of Appeal in an action against Mr. Zarko, who was who contracted silicosis while working as a stonemason for an uninsured employer. Have you been briefed in relation to that matter?
I get, Mr. Tudorhope, firstly, I do get briefed on a number of matters. With respect to the matter that you've brought to my attention, I'll need to get refreshed, but I want to hear what you have to say with respect to this particular matter. So please go ahead.
Well, it's a fairly significant matter because workers' compensation nominal insurer was successful against Mr. Zarko because of a construction of Section 140 of the Workers' Compensation Act, which in fact found that the contraction of a dust disease was not covered by a workers' compensation injury pursuant to Section 140.
Right, okay. So
I just wondered in those circumstances whether you have taken any steps to review Section 140 of the Workers' Compensation Act.
So as you are aware, Mr. Tudorhope, that the Law and Justice Committee has just recently completed a report with respect to dust diseases. The government has received that report and with a list of recommendations. A number of those recommendations have already been fulfilled. With respect to making changes to the Dust Diseases Act, which is the 1942 Dust Diseases Act.
This is the Workers' Compensation Act.
No, I understand.
This is an uninsured employer.
No, I understand. And with uninsured employers, iCare do through the general lines, and through the general lines, we'll work through that. But
Mr.
I'm
Wesley,
happy.
have you provided a brief to the Minister in relation to that case?
Not that I'm aware of, Mr. Tudorhope.
Why not?
I'm trying to get more information on it now.
Are you aware of the...
No.
So, an uninsured worker in circumstances where they are suffering a disease which is life-threatening can't bring an action because of a construction for Section 140?
I'll have to get details, Mr. Tudorhope.
Minister, in November 2023 you told the committee in relation to expanding the list of cancers covered by Schedule 4 of the Workers' Compensation Act 1987, quotes, and this is your own quote, "I've sought advice from iCare, we've sought options, I'll be working together with my colleagues who have responsibility in this area as well as Minister Dibb, Minister Chantavong and the Treasurer in a coordinated and collaborative approach to make sure that we get this right, and of course speaking to the stakeholders. Once we have some of the formal information, I'm happy to come and brief all of you." That was 2 years ago, Minister, that you told us that. What options and advice have you received from iCare?
With respect to making changes about companies that are uninsured.
No, in relation to presumptive cancers.
In relation to presumptive cancers. Mr. Tudorhope, let me say this, that you were in government for 12 years. You did make changes, and I acknowledge those changes that you have made. With respect to presumptive cancers, the government will consider anything to assist firefighters. Now, we know that firefighters, and I respect the firefighters in New South Wales, I have a deep, for me, the work that they do is not only meaningful, but as we can see, and I know from my own firefighters in Campsie and Lakemba, they do incredible work. Now, they take a lot of risk. They have an increased risk of various cancers, including prostate, skin and lung cancers due to occupational exposure to carcinogens from combustion products, diesel, petrol, and particularly when they have to deal with retardants, chemicals, and they are exposed through the work that they do. And I know that all of us here are concerned.
With respect,
are
Minister,
very
this was a
concerned,
very
and the government.
Chair, this was a very specific question. The Minister's been speaking now for the best part of 3.5 minutes. Has not addressed the question. Was what options and advice have you received from ICARE?
With respect to presumptive cancers.
Correct.
With respect
You told us back in November 2023 that you were exploring the options with your fellow ministers. What options have been put in front of you?
Look, Mr. Tudor-Hope, these are matters that the government is considering, and absolutely, we've been on the record that we do need to expand the list. Absolutely.
So, have there been options put in front of you?
With respect to presumptive cancers, where the government is considering a number of options.
Have those options been put in front of you, Minister?
Mr. Tudor-Hope, I don't know what you're getting at. What are you?
It's a very straightforward question.
Well, I've answered your question.
Are there a number of options you are considering?
I've answered your questions, and I know that you've put a bill. I know that you've read a bill in the upper house, and I understand that you're advocating, like all members of Parliament are advocating to the government. Members of this committee are advocating on behalf of firefighters. I know that firefighters do incredible work, and they are confronted with these risk-based issues. Absolutely, and
Minister,
I know that
you were very passionate about this when you were in opposition, and you and I occasionally worked very collaboratively in relation to this issue. 2 years ago, you made that commitment to this committee in relation to progressing the issues relating to presumptive cancers for firefighters. What options are you considering in relation to that?
Mr. Tudor-Hope, I know that there are concerns, there are deep concerns, and the Firefighters Union, led by their Secretary Leighton Drury, has spoken and advocated very strongly on behalf of his members to ensure that there's an expansion of these cancers in
Minister,
the schedule.
I understand that. With due respect, it
And
is a specific
the government,
question. What are the options you are considering?
The government is considering.
Point of order has been taken. Mr. Vale, on the point of order.
The question's now been asked several times, and that the Minister has answered. And Mr. Tudor-Hope continues to interrupt the Minister in answering. I just ask you to uphold paragraph 19, the procedural fairness resolution, as it relates to courtesy being provided to the witness. She's answered the question. I'd ask you to direct him to move on.
I won't uphold the point of order. I don't think Mr. Tudor-Hope is being discourteous, and he is at liberty to pursue this line of questions.
Minister, do you want to... I just repeat the question, and I'd just like you to direct your attention to the options which may be available.
Mr. Tudor-Hope, the government is considering a number of scenarios.
So there is an options paper
I know that you've put forward. I know that you've sought documents through an SO 52, and there's already a release of one of those documents about baseline with respect to all cancers included, and there's a costing. So that information is out in the public arena, but I'm not sure what you're trying to...
Well, Minister, you've made reference to the Standing Order 52. You've made reference to the standing and a costings document which has been produced. There are many other documents which give rise to, in fact, that costing document. Why weren't those documents produced?
Mr. Tudor-Hope, all my obligations have all been declared with respect to the SO 52. You asked me about the consideration. The government is making considerations. I understand the frustration of the firefighters. I understand the frustration of members of Parliament and family members of the firefighters, because we absolutely want to see more firefighters. We want to see more people entering fire and rescue, particularly women. Absolutely, particularly women.
Three of the presumptive cancers which are referred to and relate to presumptive cancers in circumstances where they are women-only diseases. Are you considering that as an option to include as the presumptive cancers?
Look, the government hasn't yet made the policy decision. It's all cabinet in confidence. But
well,
we are
thank you for
considering...
the note, Ms Campbell. I'm sure the the Minister appreciated getting that note. On what basis do you say it is Cabinet in confidence, Minister?
Mr. Tudor-Hope, the government will consider all options to ensure that firefighters...
Has it been to Cabinet,
that firefighters are protected, particularly when it comes to cancers. Now, we're doing everything that we can. We are doing absolutely everything that we can to protect our firefighters because they protect our community. They are out there each and every day. They are dealing with some of the most toxic environments when they're going out to a fire, when they're dealing with road crash. And
Minister, these are very specific questions. Have you taken a bill to Cabinet in relation to this?
Point of order.
A point of order's been taken. Mr. Namber on a point of order.
Chair, the Minister can only be asked a lawful question. The Minister's indicated this is a matter that's before Cabinet, which would in turn mean it's not a lawful question. I ask that you rule it out of order.
To that point of order, the taking of something to Cabinet is not whether or not something is before Cabinet. So it's entirely lawful to say, have you taken, where it may not be lawful to say, what is the content of the Cabinet discussions?
Yeah, it's a good point. I don't uphold the point of order. The question was, has this been taken to Cabinet, not what has been taken to Cabinet. So I note the point of order, but I don't uphold it at the moment.
Thank you, Chair. Minister?
Yes,
have you taken a bill to Cabinet?
Mr. Tudor-Hope, the government will consider its options, and I've ventilated this over the last 5-6 minutes.
And on each occasion that you have ventilated this, and Mr. Borzak has raised it also at a previous estimates hearing with you, nothing appears to have come forward, Minister. What options are you considering?
Mr. Tudor-Hope, the government is considering, and the government is making, is taking its considerations very seriously with respect to presumptive cancers for firefighters. We want to see more women in fire and rescue. We absolutely do, and we want to, and as we have seen, we're doing some really important work in emergency services, and I know that Minister Dibb has been doing fantastic work. And I'm sure you'll have a lot more to say.
Minister Dibb, you referred to the collaborative and coordinated approach with your fellow ministers. Have you been involved with discussions in relation to presumptive cancers with Minister Dibb?
Minister Tudor-Hope, Minister Tudor-Hope, Mr. Tudor-Hope, look, the reality is that we work collaboratively and we work together, and this issue has been strongly advocated by the firefighters. We know that this is it's a number one concern.
Is the Treasurer blocking you taking this? Is the Treasurer blocking this?
The Treasurer is a fantastic Treasurer.
Is he blocking this legislation?
Absolutely not. We work collaboratively.
A point of order has been taken. Mr. Namber on a point of order.
Chair, this does go to paragraph 19 of the procedural fairness resolution and courtesy to the witness. Mr. Tudor-Hope was talking over the top of the witness as she was providing an answer to the question.
Yes. Why not uphold the point of order? I don't think Mr. Tudor-Hope was being
apologise.
discourteous, but he was interjecting and not really giving the Minister a chance to answer. Minister,
is the Treasurer blocking?
The Treasurer is the Treasurer is one of the best treasurers in this state.
No, I didn't ask
He
that.
is doing well. He is doing an extraordinary job.
I think he's the only treasurer.
And in the history of New South Wales, he's a brilliant treasurer who's doing a great job and working through the mess that your former government left behind.
Okay, Minister.
Well, you don't like to hear the truth. You don't like to hear the truth.
Let's cut to the chase. Let's cut to the chase. If you actually are serious about this, will you support the bill which I have introduced into the Parliament?
Mr. Tudor-Hope, we are absolutely serious, and our government works in collaboration, and we'll consider every bill like we consider every other member's bill, and we'll go through a process.
Have you reviewed the bill?
I heard about your commentary. Heard about the commentary.
You haven't reviewed the bill?
Your bill?
Yes.
I've had a look at your bill.
Well, and what's the advice you've received?
Why
is the advice that you could support the bill?
Mr. Tudor Hope, why didn't you do it in government? You had all that time.
There is a bill before the upper
Well,
house at
you
the
don't
moment.
like to talk
Will the
about-
in relation to exactly the matters which you undertook to bring to the Parliament and have not done. Will you support that bill?
Mr. Tudor Hope, you had 12 years in government and you didn't do any of this work.
Will you support this bill,
We are
Minister?
cleaning up your mess.
Will you support this
The
bill?
government considers every member's bill according to the processes.
This is something you undertook to do. Will you undertake to support this bill?
Mr. Tudor Hope, as I refer you to my previous responses.
So the answer is no, you won't support it?
Mr. Tudor Hope,
A point of order has been taken. Dr. Kane on a point of order.
The Minister has answered the question, I think 3, 4, possibly 5 times, and Mr. Tudor Hope continues to ask the same question, and I will invoke paragraph 19 about courtesy. The question's been answered. A couple of goes is fair enough, but 4 or 5 is really pushing the boundary.
Well, to the point, with respect, she hasn't answered the question. I've asked on a number of occasions
Just 'cause you don't
whether
want the
she will
answer.
support the bill.
Further to the point.
She may
of
not
order.
want to answer.
Order. Further to the point of order. Mr. Namber on a point of order. Further to the point of order.
Further to the point of order, Chair, asking the same question a number of occasions is now on the verge of badgering the witness, and that is discourteous to the witness under paragraph 19.
Well, yes, I won't uphold the point of order. I don't think Mr. Tudor Hope was being discourteous. I think the Minister's answers were relevant, just, but the member is free to continue to ask those questions, but I would remind him to avoid interjecting.
Thank you.
And allow the Minister to
Thank you,
give
Chair.
a full answer.
Thank you, Chair. So, I'll just one last time, Minister. Will you support the Workers' Compensation Amendment Firefighters Diseases Bill 2025, which is exactly what you campaigned for, which is currently before the Legislative Council, and if not, why not?
Mr. Tudor Hope, our government has overwhelming respect for the firefighters of New South Wales. Absolute respect. And we will assist, we will do what we can to support these hard-working men and women in fire and rescue. I thank them for their service. I thank for everything that they do. And you can see from, and I'm sure that you've gone through the decision of the full bench of the Commission, that there's a lot of work that your government did not undertake. So there's a lot of lessons learned. There's a lot of lessons you shouldn't learn
whether
there.
you would support a bill which you advocated for, and you won't give me a direct answer.
Mr.
I'll move
Tudor Hope,
on in relation to it.
The government will consider.
And it makes a lie of the fact. It makes a lie of the fact that you will do everything you can to support hard-working firefighters.
Mr. Tudor Hope,
Order.
I reject that.
Order,
I reject being called a liar.
Order.
Minister.
Mr. Tudor Hope,
Yes, sorry.
let's keep things civil and avoid commentary and ask questions, please.
Minister, the threshold for bringing a work injury damages claim in relation to a workplace psychological injury, including a psychological injury caused by a workplace sexual assault, caused by employer negligence, is 15% whole of person impairment. Are you aware of that?
Yes.
You are? And Minister, Schedule 1, Item 19 of the Workers' Compensation Legislation Amendment Reform and Modernisation Bill 2025 would lift the threshold to 31%, a threshold seldom reached even by victims profoundly psychologically injured by that sexual assault. Are you aware of that?
Keep going, Mr. Tudor.
Well, I just want to make sure, Minister, that you are across the detail of this because it is important. Are you aware of that?
I introduced the bill in the lower house.
So the answer is you are aware of it.
I don't accept a lot of your premise, but anyway, go on.
Well, in actual fact,
I'll come back to it.
the time for opposition questions has ended. It's now time for the crossbench. Ms. Boyd, you have 20 minutes.
Thank you very much, Chair, and good morning to you, Minister, and to all of the officials here today. Can I just start with something a little technical. Just looking at the... Sorry. Yeah, there we go. So looking at iCare and the pressures on the system, in the June 2024 valuation, Finity observed that average weekly payments per active claims were higher than expected for most accident periods and have increased faster than benefit indexation. That added about 146 million to liabilities. In the December 2024 valuation, they again found that average weekly payments continued to increase faster than benefit indexation and explicitly quantified a 236 million increase for that factor alone. So what this is getting at is the PRW remediation from 2022. The assumptions weren't correct, is my understanding, and the increase in indexation as a result of that original error has contributed almost $400 million of the increase in liability valuation faced by the nominal insurer in 2024. So that's 400 million of the pressure on the nominal insurer that's directly attributable not to claims trends or performance in any way, but directly attributable to iCare's own mismanagement of the scheme. Have you been made aware of that significant driver of the liability?
There's a number of... I've been aware of, and I've been briefed on a number of adjustments, but with respect to, so this one I'm happy to take further brief on that. Mr. Wessling, if you're able to elaborate further.
Yeah, thanks for the question, Ms. Boyd. We've had those periods where average weekly payments did increase above inflation, and the actuaries have been trying to understand what drove that. They haven't attributed the full amount to the various remediations that occurred, but the driver that they attribute to those remediation programs is that as we went through the program, contacted injured workers, a number of claims reopened in effect. So there was additional payments made beyond the remediation payments on those claims. I would just state though, the actuarial analysis doesn't attribute that full cost over wage inflation just to those remediation activities.
No. So, but they've re-baselined. It resulted in a re-baselining of the wages on which they were then paying the claims amounts going
true, yes.
forward.
Yes.
So that basically I'm trying to think of a non-sweary way to say it, but the mess up with the PRW remediation from a few years back is still being felt in the system. And so I guess my question to the Minister is, when were you made aware that that $400 million was coming from that previous iCare mistake, and that pressure on the nominal insurer is actually quite a significant amount?
Look, I don't want to give you any... I want to give you correct advice. So I'm happy to take that on notice.
Okay, thank you. Turning to another technical iCare issue, just wanted to ask, and maybe I'll start and direct this directly to Mr. Wessling first then. When an employer first crosses into the experience rated pool, is it the case that their first year of claims experience may be excluded or annualised depending on how the calendar month aligns with iCare's calculations?
I'll have to get it. Can I take that on notice and get you a technical answer?
Yeah. I think what we're looking at here, and what I've been hearing about, particularly from small businesses, is that iCare shortens the first policy period for some employers, so it aligns with the end of the month. So
that's correct, yes.
Right. So what is the official term that you use for that practice internally then? Is it date rationalisation?
I believe that's the case, yes, Ms. Boyd.
How many employers in the past 3 years had their first year of experience rating partially or wholly excluded because of date rationalisation?
I will see if I can get that information for you.
Thank you. And if you could tell me how many employers have had their first policy period shortened in that way since iCare assumed responsibility for the nominal insurer?
Okay.
On what legislative or regulatory authority does iCare rely to shorten a statutory 12-month policy period?
Well, I will take that question on notice as well, but I can say all of our premium and underwriting processes are linked back to the market premium and practice guidelines, which is really the basis by which all of the premium activities are undertaken against.
Yeah. Did iCare ever seek or obtain explicit approval from CIRA to implement the practice?
I'd have to take that on notice, Ms. Boyd.
Do you know why the adjustment's not disclosed in policy documentation, premium guides or employer communications?
I will have to take that on notice, Ms. Boyd.
If you could tell me what proportion of employers transitioning from small to experienced rated status are affected by date rationalisation?
Sorry, could you say that again?
What proportion of employers transitioning from small to experienced rated status are affected by date rationalisation?
Okay.
Now, coming to the crux of the issue, that shortening of the first policy period affects an employer's ability to carry forward their claims performance into future premium calculations. So it has the effect of keeping their premiums higher for longer. My understanding is that actually this practice breaches the market practice and premium guidelines principles, and that CIRA initially determined that it had no legislative basis. Can you explain why iCare continues to use this practice?
I can't explain that, Ms. Boyd.
Minister, are you aware of the use of this practice, which is resulting in a lot of small businesses ending up paying higher premiums than they should be?
Look, I'm not aware. I'll take that. I'll take advice on that. But where we can support small businesses with respect to premiums, absolutely, we will do so. One of the when we made the changes to iCare recently, there were a number of objects that we included into the bill with respect to a sustainable financial scheme, but also having injured workers and premium holders at the centre. So, yeah, we'll get back to you on that one.
Thank you. And if it's found that this practice is continuing, which I believe it is, my understanding is it's also the case that some employers have had that date rationalisation reversed when they raise it with iCare, while others have not.
Okay.
What criteria govern those decisions, Mr. Wesley?
Again, our decisions are governed back to the market practice premium guidelines. So
Okay.
I'm not aware of reversals. I'll have to go and have a look at that.
Thank you. If, again, I understand you have to take this on notice, but perhaps you can come back this afternoon because this is quite a serious issue. If this practice is occurring and it does breach the market practice and premium guidelines, will you commit to retrospectively correcting premiums for all affected employers and prohibiting the practice going forward?
Yeah, I'll have to have a look. Obviously, we'll take that away and have a look at the details.
And Minister,
I think that, I mean, you've brought forward a very important issue, and it was only a few weeks ago we were down in Nowra for a mobile engagement forum with the Shoalhaven Business Chamber and over 200 registered business NGOs, manufacturing, and a number of those organisations raised issues with us. We were making, obviously the iCare team were making their operational inquiries. We will come back to you, but yeah, I appreciate you bringing that forward to us today.
Thank you. Another issue in relation to premiums. For experience-rated employers, claims only affect premiums for 3 years, is my understanding. But for LPR employers for 4 years, and after that any deterioration is no longer counted. Is that correct, Mr. Wesley?
That is correct. There is an adjustment made in the 4th year for further expected claims cost.
And what is the, and again, appreciate you may need to take this on notice, but what's the total dollar value of claims costs that emerge after those cut-off points each year, and who pays for them once the employer is no longer accountable?
I will take that on notice.
Thank you. From a structural perspective, though, if you've got these experience-rated employers, if they've got let's give a sort of a worked example. If you've got somebody, an employer who has a worker who suffered an injury in year 1, after 3 years, basically that gets wiped for that particular employer, but that person may still be requiring ongoing costs through iCare. Is that ongoing cost then just dealt with by the pool, by iCare as a, there's no sort of additional consequence on that employer after that time?
Yeah, that's correct. So each of our products, we only have 4 products, essentially are pooled, and there's an element of pooling in each of those. There's no product we offer that is self-insurance, so there is an element of pooling. So with the experience-rated product that you just mentioned, there is, and the LPR, there is a portion of the cost of the claims that is borne by the employer, but not the full amount, because there's risk pooling in place.
Yeah, but if you're a small business,
if you're a small business, there's no impact of your claim on your premium. The impacts are dealt with at an industry level. We price at an industry WIC, code for the smallest employers.
Yeah. So whereas small employers are bearing the risk with their premium of an entire pool, if you're one of these larger businesses or experience-rated employer, you, I guess, aren't subject to that same sort of pooling of risk after a certain period of time.
Well, there's certain cappings that are in place. There are certain cappings in place, that's right. So there's an element of pooling. It's just more directly risk-rated for those larger employers. And the experience applies to the premiums paid more than they do for a small employer where there's no credibility against the claim.
Yeah. And is it correct that LPR employers only pay a deposit premium up front rather than a full risk-based premium?
So that's right. There's the mechanism for the larger employers is that there's an estimate of the premium paid up front, and there's, I guess, more at risk depending on the performance of that employer, and that's done through these true-ups that apply every year against actual claims cost at that employer level.
I understand iCare relies on T Corp investment returns to subsidise premiums and cover long-tail liabilities. If these LPR employers are only paying deposits, it's true then that iCare has less investable cash, and so it's foregoing years of compound returns at the same time as it's left holding long-tail liabilities in respect of those employers. Is that correct?
Well, that's sort of correct, but because we set the premiums for each of those products, the benefit of the investment that goes against the premiums held for small employers applies to those premiums. So it's built into the premium calculations, the benefit of investments.
Have you calculated how much investment income the scheme's lost because those deposits give you less investable cash than if the full premium had been received?
Well, I don't think we've lost any investment return because it's factored into the premium that's paid.
But in terms of the amount that is sitting in the fund that's able to be invested and returns paid into the fund in the same way that a small business's premium is used?
So the time value of money that is lost, I guess, in the case, is factored into the premium calculation for the larger employers. So it's factored into the way premiums are collected.
If large employers are not only able to externalise long-tail claims after 4 years, but also denying iCare the opportunity to use those funds, I understand what you're saying about you think that there's kind of larger premiums, but they're not paying those premiums. They're sitting in their own bank accounts. Aren't we really, it's like a double subsidy paid for by the rest of the scheme to prop up these big employers?
I don't believe that's the case, Ms. Boyd. As I said, the premiums that we collect premiums every year to pay for the claims we expect to be incurred in that year. We set those premiums for those products in those product pools. So the premiums we set relative to a break-even premium are set for each of those pools. The way investments and claims factors into those is different, but we still collect the amount of premium we expect. Remember, in the case
when
of
you
LPR...
say collect the premium, though, it's sitting in their own account. For these large employers, that the actual fund, the amount is actually with them. They're not paying they're not paying the entire amount into iCare in the same way that a small business pays their premium into iCare, correct?
But in addition to the base premium that we collect in the LPR product, we're also collecting costs against the claims that are actually being incurred and paid. So yes, there's a timing of those cash flows, but as I say, that's factored into the premium calculations.
But the cash is still sitting with the employer for them to use however they like, whereas a small business has to take that cash and sacrifice it, put it into iCare, which you then use within the normal insurer to earn returns and spread the risk with everyone else and all of the other things.
I think with larger employers, though, we're collecting a premium for the base fee. We're also collecting premium to cover claims from prior years and claims in the current year as well. So we're collecting premiums that cover the base premium plus claims all the time.
When there are claims, but
Yes.
the point is still that they're not paying their full premium to the extent, so if there were no claims, then they would just have that cash themselves. Whereas for a small business, they've had to put that premium in.
I don't believe it's a case that it's unfair because, again, we
I didn't say it was unfair.
Sorry?
I didn't say it was unfair.
Sorry, okay,
you
sorry.
said it was unfair.
I don't believe it's... we're factoring the time value of money into the premium calculations. So what I can assure you is that we treat the LPR product as a pool. We know how... the actuaries calculate how much premium do we need to collect to cover those cost of claims. The cash flows work out slightly differently, yes, to the way they do for a small employer, but it covers the cost as outlined. So if we get less investment income, that essentially translates into a slightly higher premium being paid.
Okay, but 88% of small employers haven't made a claim in the last 5 years, but they're still having to pay their premiums in full.
Yes.
Whereas if you're a part of this LPR product, you get to basically hold on to your cash until it's called on. You don't think that presents some, as you said, unfairness for small businesses versus large businesses?
Chair, I'm going to take a point of order just in relation to the one question that this board is taking as it's directed towards a public servant. In particular, this question was seeking an opinion. The use of the words, you don't think this is unfair, or would suggest to me that Ms Boyd is seeking an opinion from a public servant, and I'd ask you to rule that out.
I'm very
of order.
happy to direct that directly to the Minister.
Okay, yeah, I do uphold the point of order. If you could maybe direct that to the Minister, Ms Boyd, that would be very helpful.
Minister, you can see where I'm going with this.
Yeah.
The policy structure within iCare is pretty complicated, but when you drill down into it, there's a number of factors that are not playing in favour of small business. Would you be concerned if the large businesses were effectively not contributing their fair share, putting the burden on small businesses with higher premiums?
Look, as Mr Wessling and our officials are happy to, they're taking your questions on notice. They'll come back to you. With respect to my opinion in terms of a policy decision, I think we need to look at the evidence, look at the facts. Happy to look at the small businesses who've raised these issues with yourself. Happy to consider those, and to let the committee know as well that there have been a number of changes to iCare over the last couple of years. I'll also be issuing my statement of expectation for iCare, and I'll have that tabled so everyone can see the government's expectation. Of course, we're working together with our agency, with the key stakeholders, premium holders, where there is a concern. Of course, we will consider options. So happy to talk to you, and we can talk to yourself and meet with our iCare officials.
I'd also be keen just to get you on the record of, would you be concerned, and I guess, are you interested in ordering a review or doing something to get to the bottom of exactly what burden is being put on small businesses versus big businesses under the structure of the premium setting?
Miss Boyd, I'm not going to make a bullet a gate
worth a try.
policy decision on the run. I'm a diligent person, and I want to make sure that we have all the facts and information. And as you know, that I'll tend to that and respond in a timely way. And happy for us with our CEO and Mr. Wessling to meet with you, and spend more time and work through and have our officials, but definitely work with you on this matter.
Thank you.
Thank you, Minister. Mr.
Thank
Tudor
you,
Hope.
Chair. I just want to clear up a few things first, Minister, before returning to your Amendment Act. Minister, you made reference earlier when I was talking about workers' compensation, nominal insurer versus SACO, to a review of the Workers' Compensation Act, and you, I think, indicated that you'd already implemented a number of recommendations contained in that review. Are you prepared to table that review?
This is the Law and Justice Committee.
So that's the only one you're referring to. There's not an internal review which you have done.
So, Mr. Tudor Hope, there's as you know, the Law and Justice Committee recently
but it didn't
completed
cover uninsurance, did it?
with respect to. I'm not aware. No.
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 Right.
What?
Which that case was specifically addressing was uninsurance. So there would be nothing in that document which addressed the issue of uninsurance.
So no. Just to go back to the Law and Justice Committee, have got a number of recommendations.
Yep.
It's in the public arena.
No, it's fine.
But
you also made reference to a document which had in fact been produced relating to the costing of some modelling which had been done. They were produced in confidential documents, and you, having made reference to that document today, are you prepared to table that costings document?
What do you mean if I...
There is a modelling document with costings for presumptive cancers which has been prepared for you. Are you prepared to make that document public?
Mr. Tudor Hope, all my obligations with respect to all my obligations and all the processes have been met, and I have nothing further to add. I've nothing further.
It's a specific question. You made reference to a modelling document which you'd received.
We provided every document.
Will you make that document public?
We provided every document that we had. Mr. Tudor Hope, through the order, through the process.
Are you sure that that's the case, Minister?
We have fulfilled the obligations with respect to this order, and there's a process, and we've gone through that process.
Well, at the risk of incurring Mr. Vale's ire, I will ask you again. I will ask you again. There is a document which has been produced. Are you prepared, having given the evidence which you gave earlier, to have that document made public?
Mr. Tudor Hope, our obligations with respect to the document in reference have been met through the order, and I have nothing further to add.
Well, are you aware of on what basis those documents were provided?
Which documents are you talking about?
The documents you say have been provided to the House pursuant to the order.
The SO52?
Yes.
So what's your question?
Are you aware on what basis they have been provided?
We have followed the process, and we've...
So you say that they are documents which has been produced in response to the order?
We have fulfilled our obligation.
So on what basis do you say the documents have been produced to the House?
What do you... sorry, you're going around in circles. We fulfilled our obligation.
Minister, I can
refer you to Miss Campbell.
Yeah, thank you. Mr. Tudor Hope, there were a number of releases under the Standing Order 52. The document that we're referring to was released under cover of letter from the Cabinet Office Secretary and was released on a confidential basis. You're correct.
Correct. So, Minister, having made a disclosure of that document today, are you prepared for that document to be made public?
Mr. Tudor Hope, sorry, Ms Campbell.
Well,
sorry, Minister.
it's a question for the Minister, quite frankly.
No, I'm going to seek Ms Campbell's assistance. Thank you.
Thank you, Minister. I think the Minister would seek advice on that at this stage, Mr. Tudor Hope. Thank you.
I'll return to the Workers' Compensation Amendment Act. Minister, I was asking you about the threshold for a profoundly injured worker which exceeds 30, which arises as a result of a sexual assault, having now to meet a threshold of 31% for continuing damages pursuant to the Act. You're aware that that's the case, I think you told me?
Yes, Mr. Tudor.
Why do you say that it is reform and modernisation of the workers' compensation scheme to cut off access to workers' injury damages for victims of workplace sexual assault caused by employer negligence?
Mr. Tudor Hope.
Is that reform?
Mr. Tudor Hope. Have you read the amendment that you have introduced?
No, I'm asking.
No. You can't target me on this when you have to look through the consequences of the amendment that you've introduced.
No, well, I'm happy.
I'm
asking the questions, Minister. Are you happy?
No, because
are you
it's got to
happy
be
with that?
You've got to put it in context.
Order. A point of order has been taken by Ms. Saval. Order,
context.
Minister. Order.
The Honourable Damien Tudor Hope asked a question to the Minister that was loaded with argument and imputation. It is only fair and procedurally courteous that the Minister be afforded the opportunity to answer that question in full, as she is doing. I'd ask you to remind Damien Tudor Hope of his obligations under paragraph 19 of the Procedural Fairness Resolution to afford courtesy to the witness in what was a question that was loaded with imputation and argument.
Well, I think the question...
It's a specific question about the provision of the Act which this Minister has introduced and
Well,
whether that constitutes...
Is this to the point of order?
Reform. Yes.
Yes. Look, the member's question was not out of order, although imputations, like we were to avoid imputations according to the rules of the House. But if we were to rule out every question in this hearing that had argument in it, then we wouldn't be doing anything at all. But the hearing was not helped by the interjections of Mr. Tudor Hope. The Minister was about 30 seconds into her answer. I don't think it was the answer Mr. Tudor Hope was hoping for, as per usual, but he was beginning to interject. If we could avoid that and allow the Minister to answer in full, that would help us.
Let me just clarify the question, Minister. I'm asking about sexual assault, which is contained within the bill you introduced, not about any amendments. This is about something which is before the Parliament at the moment, which you have introduced. Is it your view that limiting damages for sexual assault caused by an employer's negligence is proper reform?
Mr. Tudor Hope, the Premier and the Treasurer answered these questions when you put this to them. But let me tell you that the government has got a bill in your place that for I don't know why there's no rhyme or reason, and you haven't explained this to either workers or business community what you're doing. You're holding it up for, I don't know what the reasons are, but if you have a look at the amendment that you've introduced with respect to your amendment is asking victims to basically prove that their perpetrator knew that they were sexually assaulting or sexually
reasonably to have
harassing them in the workplace.
Or ought reasonably to have known.
No.
Yes,
You
yes.
cannot get away with this. Is this the modern Liberal
Minister-
Party? Is this what the Liberal Party think? That women who are victims of sexual harassment in the workplace have to prove,
Minister, quite
have
frankly,
to prove
quite
that their
frankly, if you want to get
perpetrator.
in that argument,
well,
if you want to go down that
well,
argument, this is the greatest disgrace I have ever seen.
Well,
introduced.
is this the modern Liberal Party? Is it?
This is the modern Labor
Is
Party.
this the modern
Minister?
Liberal Party?
Minister, when did you first learn that you were going to take away workers' rights who had a whole of person injury of 31%, up to 31%? When did you first learn that?
Mr. Tudor-Hope, the government has introduced an important reform with respect to supporting workers who are impacted by psychological harm and risk in the workplace. We have introduced a holistic reform worth $344 million. It's the first time in the history, in a very long time, that a government is investing $127 million in safe work. We've got a standalone agency, we've got our inaugural commissioner, and we're investing an additional 50 inspectors,
was it
20 of
your
those
idea?
are psychosocial.
Was the 31% your idea?
Mr. Tudor-Hope.
Was the 31% your idea?
Mr. Tudor-Hope, the government has put forward its view, and with consultation, alongside consultation with a range of stakeholders, including unions and business and academics and medicos and colleagues. My colleagues have been instrumental in putting forward important
I've asked a number of
feedback in
ministers
terms of
about
changes to from the original exposure to where we are now.
The
Now let me tell
31%
you,
hasn't
when I
changed.
inherited iCare and looked into the books, you guys left a massive mess.
So your
that we
solution
are having
is
to clean up.
solution is to take away workers' rights.
No, our solution. Well, your solution.
Did you
is,
seek
Your
advice?
solution is increasing premiums for small business and allowing people to languish in a system. Is you've allowed workers to languish in a system. You have not done any work in triaging or early intervention or
Does
prevention.
this bill do that, does it?
This is absolutely it does.
well,
absolutely it does.
Minister,
Well, you haven't read the
Well,
detail.
Minister, did you seek any advice from the Injured Workers Network or other stakeholders about the impact on the injured workers of this change, or is it solely driven by iCare's actuarial model? Because you've told us today this is all about saving dollars. All about saving dollars. So did you actually talk to
putting
injured
words in my
workers?
mouth.
Did you actually talk to injured workers?
You're putting words in my mouth.
Did
This
you
is
actually?
a holistic
I'm asking
approach.
the question. Did you actually talk
When we
to
came into government, we saw a massive spike in the number of psychological injuries in both the NI and the TMF. The reality is that your government left people to languish in a system, in this type of system, where this is a claims process, and this is what these people have to endure every single day. What we're trying to do is we're investing in the workplace. We are investing $344 million. This is the first time in a very long time where iCare, Safe Work, the agencies are working right at the beginning in workplaces. We are out in workplaces. We have made changes to the Industrial Relations Commission, expanding the anti-bullying and harassment jurisdiction. So we have stopped bullying orders. We have to get, and bosses have to lift their game in improving. The bosses of this state have to lift their game in improving in the way they deal with bullying and harassment in the workplace. Now, it starts from the workplace, and we have Safe Work and our agencies working together in collaboration with the unions, with business. We've got a tripartite advisory council that is going to do exactly that. This is holistic, Mr. Tudor-Hope. It is holistic.
Yeah,
but we can't
Minister,
have people,
Minister, you've made
we've got people languishing in the system. They're getting secondary psychological injuries. No, because this is
it's a speech.
This is political. No, this is because
political.
I'm passionate about this. You know why?
I'm more
Because there are so many people that have been languished in the system, that are languishing. They've had no early intervention. They've had no one look after them and triage, because we've got a 100-year-old system that's based on physical claim. This is all new to all of us. So we're working through a system. There are many checks and balances in this reform. And let me tell you, you have
Minister,
your constituency.
Order. Mr. Tudor.
Your own
I'll call
constituency.
Mr. Tudor Hope to order for the first
Minister.
time. Order, Mr. Tudor Hope. Mr. Tudor Hope. The resolution, the procedural fairness resolution demands that witnesses at these hearings are treated with courtesy at all times. That was discourteous in the extreme.
Thank you.
And I would ask you to consider withdrawing that comment
Minister,
and continue on, but do so in a
Minister,
civil manner.
Minister, I'll ask you again, very simple question. Was it your idea to introduce the 31% whole of person incapacity test?
I'm part of the Minns Labor government. I'm very proud of the work that
Good,
we have
thank you.
done to support working class people.
That's fine.
I am very proud of the work that we have done, as opposed to your government, who let people languish in a system and have secondary psychological injury claims. And in order for us to have a sustainable scheme for working people who are injured in the workplace, we are making a holistic change, investing in money in workplaces and in our agencies to be out there with workers.
Let me ask you about that, because that's something that you want to give us a speech on. But have you been following the evidence given before the committee inquiring into this act?
From the upper house, the upper house.
Have you been following the
inquiry.
evidence?
I've watched the inquiry.
So did you listen to the evidence of Dr. Doug Andrews?
I'm familiar.
And he was invited to give evidence to the inquiry in relation to your first bill at the suggestion of government members. Mr. Nanva will recall this evidence, I'm sure, well, when he said, "I cannot recall an injured worker who rated higher than 21% whole of person incapacity who had been determined by me or another assessor as fit to work in any capacity." So are you proud today of the fact that you're going to cut those workers off from any entitlements?
A point of order has been taken by Mr. Nanva. I think you just got in just before you, Mr. Val.
Pip me at the post, here you go.
Thank
Might
you.
be different to mine.
Thank you, Chair. This just goes to Standing Order 63 in relation to debating current proceedings before a committee. Mr. Tudor Hope is referring to some evidence that was given before a committee, before the committee's resolved on that evidence, resolved to hand down a report. You can't ask a question that relates to debating committee proceedings that are currently on foot.
To the point of order, that doesn't apply here. That's a ridiculous point of order. I'm sorry, Mr. Nanva, that is not a thing.
I'll take some advice on that. I won't uphold the point of order at the moment. I'll just get some advice from the clerks on that. But if we
Chair,
can come, if we could,
mine is a
sorry,
different point of order.
Yours is a different point of order. I'm going to get some advice on that.
Can I just keep going, because I've got.
No, I do have a different point of order. And
Well,
that is
and there's
that
another point of order, and the other point of order,
Mr. Tudor Hope has disclosed what I would consider are confidential deliberations of a committee in this forum, in that he's suggested that the government were to put forward a certain witness.
Yeah, it's in the minutes.
Were to put forward a public evidence. So I just suggested that perhaps in your consideration of that, you consider whether or not that has occurred here.
It's in the minutes.
Well, I don't know that. So these are things I don't know. Well, I'll take some advice on those. So I'll reserve my.
To the point of order,
Yes,
I understand you reserve, but if it will assist you, Chair, as a member of that committee, as somebody who heard that evidence given in public, as somebody who has seen that evidence repeated in public, it is very clearly in the public domain.
Okay. Well, that's noted. I'll take some advice. I'll reserve my ruling on that, Mr. Tudor Hope.
So, Minister, in light of the expert evidence, why did you include in the workplace compensation legislation the second bill, the Reform and Modernisation Bill, which you introduced on the 6th of August 2012, provisions removing the current access to ongoing financial and medical supports for workers with a psychological injury and a whole of person incapacity of between 21% and 30% who are not fit to work in any capacity?
So you're asking me about an important view from a medical professional.
Well, he's the government's chief psychiatrist in the Workers' Personal Injury Commission.
Yeah, so, you know, I listen to what the experts have got to say, but we also have to undertake a holistic approach when we're dealing with psychological harm and injury in the workplace. These matters, Mr. Tudor-Hope, are very new. They've come to workplaces between the last 5 to 10 years. Prior, there weren't that many psychological injury claims put through insurance companies.
Can I just ask you this, Minister, how do you expect these workers to support themselves and to get medical treatment?
Mr. Tudor-Hope, okay, which industry are you talking about? So you're asking me a one-size-fits-all question.
No, I'm asking you this cohort of workers between 20 and 30%.
No, you have if you really care about this, you would put to me the industries because there are different complex issues in every industry. So in not-for-profit, in business, in small business, in private sector, in government sector, these claims, well, you can shake your head all you like. I talk to injured workers all the time, and as much as it's a robust discussion...
The bill isn't industry-specific, Minister.
No, but you don't understand the claims process.
You sold out
and
injured workers, Minister. You've sold them out, and you can't even tell me...
Order, Mr. Tudor-Hope will come to order and desist.
I don't take
comments.
I'm not going to be lectured to by you about workers' rights.
Minister, please come to order.
Oh
Mr. Nandra on a point of order.
Have a look at presumptive cancers, Minister.
That is highly discourteous to the witness. I ask you to call Mr. Tudor-Hope to order for the second time.
But true.
It is. I uphold the point of order. I won't call the Honourable Damien Tudor-Hope to order for the second time, but would ask him to refrain from making statements and commentary. And I'll remind him that he's already been called to order once. Ms. Boyd.
Thank you, Chair. All right, I'm going to get really radical and talk about the budget. I know, it's wild. Minister, can you explain the more than 55% reduction in distribution to the Workers' Compensation Dust Diseases Authority in the most recent budget?
Can I refer to one of my officials?
I don't have that.
They're all fighting to do it.
It's all right.
Who's going to do it?
Notice.
You'll take it on notice? Yep. Okay. On the 14th of August, you released the long-awaited Silica Worker Register regulation. Can you confirm that the register will not be retrospective?
Let me take that. I'll get a note on that for you. But can I add further to that, Ms. Boyd, that the government, as you're aware, very recently set up the tunnelling task force with a number of experts from both private sector, government agencies, occupational hygienists, and happy to brief the committee on the work that, and of course, Commissioner Scorer is chairing the task force. And what we're trying to do is we've got different parts of this issue in terms of silicosis. It's about how we coordinate, bring it together in terms of identifying, so knowing who we have to screen, knowing the workplaces, making sure that we're monitoring and recording. We've set up the Silica Register, but I'm happy to refer to Commissioner if you've got anything further to add with respect to the Silica Register.
Yeah.
So confirming, yes, it's correct that it won't be retrospective and it will be launched on the 1st of October this year.
So if it's not retrospective, then that means that workers exposed to silica dust in the processing of manufactured stone won't have their information recorded in the register? Because that's been banned now, so it'll all be retrospective?
That's correct.
Was that a mistake?
I think there's a point in time where you have to draw the line, but I think what we're trying to do through the task force as well as through the tripartite working group is to develop, particularly with iCare and CIRA, how do we, and with health, how do we gather that information, both from a worker's perspective, so that they can track their history over their lifetime, because these sort of health things, these are health matters that might take time to emerge, but also for research and academic purposes.
Sure, but putting tunnelling to one side, because that's an ongoing thing. If we look at the engineered stone issue, which thankfully we've now had a ban, the entire point of why we established this register was to track workers who had been working with engineered stone. But the way that this has been drafted, this regulation, is it won't apply to those people. Was that a mistake?
I can't comment on the drafting of the regulation.
Does that sound like a mistake, Minister?
Look, I'll have to go back because we introduced legislation a couple of years ago with respect to the register. Let's have a look at that because particularly when the ban came in, when the when engineered stone was banned, we also set about, we expanded a number of inspectors going out to, backyard installers, making sure that they're not doing this and going through. There's obviously a residue, so to speak, in terms of people who are doing things illegally, and so we need to sort that out. I can get you a briefing on that, but with respect to the monitoring workers who have worked in these installation places, I know that Safe Work had done some work with respect to going out to these places before the ban came in, making sure that they were following processes. And I know that there might be some information that we can get for you, but we absolutely, I know and you know, that there will be an increase in the number of workers in the future who will be diagnosed with silicosis. So I am very aware that this is at our doorstep as we speak.
When that WHS amendment bill in 2023 was introduced, you said, this is from the Hansard, quote, is envisaged that the register will inform health screening, enable epidemiological research and research on the incidence, distribution and control of the disease, and track engineered stone workers who are exposed to respirable crystalline silica and workers in other high-risk industries, end quote. The regulation doesn't uphold what the intention of the register was. Having now heard that, will you go and look at the regulation?
Look, we'll definitely have a look at that, but it doesn't preclude workers doesn't preclude workers who've worked in these engineered stone installation places. They can still access eye care services, for example, even if they aren't on the register. As you know, we have our lung bus that constantly travels across New South Wales, and we will, and obviously people can make appointments. Employers can also make appointments for their employees, but we'll have a look at that.
I mean, I hope it's just an oversight because it's and something we can fix fairly quickly. Can you explain the justification for the exclusion of coal miners from the register?
I'll refer you to our commissioner.
I think we'd have to take that on notice about the. What I would say though is that there are other reporting systems. So there's a national system for reporting as well as our register. So and part of obviously the future work is how do those various registers talk to one another to be able to track workers. But we're happy to look at that.
Can I just and without I don't want to sorry apologies Commissioner. I don't want to. I want to get the correct information, but coal miners have their own, as you know, they have their own resources regulator. They have their own comprehensive screening processes and systems. So prior to this, there was an engagement, my understanding, with the agencies, but in the break or in the afternoon, we'll get you that information.
Thank you. I do
about
understand
the justification. But when we did bring this forward, there were discussions with respect to coal miners, but they have their own very comprehensive process.
They have their own compulsory testing regime, but in
Yeah.
terms of having,
Yes.
a database of workers in order to track the exposure, I think
They're a lot, like we're looking at the way that the coal miners do it. They've done a good job over the last few years. They've done a very good job actually, where you've got your tripartite, and they're all working together. So you've got your companies and the union very much invested in the health of their workforce. And this is something, for us, this is something that's, particularly for regulators across the world, and seeing that silicosis, people weren't getting diagnosed, it was more asbestosis or mesothelioma. Now we are going to see a rise. I don't have those figures, but I don't want to take up your time, but yes, we'll have a look at that.
Thank you. And Ms. Scorer, you just talked about the national register. My understanding is that's for confirmed cases, whereas this register is for sort of health screening and sort of exposure and health screening. So it's okay. Can you explain the justification of the exclusion of interjurisdictional information sharing? I understand there was a draft regulation that did have interjurisdictional health screening, but it didn't make its way into the final regulation.
So having other interstate workers being part of this.
Just the information sharing, where a worker has worked across multiple jurisdictions.
Yeah. Happy to have a look at that. There's probably a reasoning for it. But absolutely, where we've had workers working in New South Wales, we want to monitor even once they've moved interstate. But let me get that information for you.
Thank you. And then a final one on that regulation. Can you explain why it doesn't require employers to notify Safe Work of the outcome of a dust diseases health test?
I'll refer you to the Commissioner.
One of the areas of work that we're looking at, obviously it has a focus through the tunnelling task force, but it does broaden out, I think as you're alluding to, Ms Boyd, around other dust diseases, about how we do expand and have a different sort of data repository, particularly so that workers in the future. So that's a sort of a further iteration that we're starting to contemplate now.
Okay.
Yeah.
Thank you. Turning to something different, Minister, Queensland firefighter Izzy Nash was killed on duty during a factory fire in 2023, and the Queensland Work Health Safety Prosecutor has now launched court proceedings against the Queensland Fire Brigade for failing to comply with their safety duties. In New South Wales, I understand Fire Rescue New South Wales are seeking to reduce minimum safe and effective crewing at an incident from 4 to 2 firefighters in 10 regional centres. Given the dangerous nature of firefighting, do you have any concerns that this initiative may lead Fire Rescue New South Wales and New South Wales Government vulnerable to court action?
Yeah, look, with respect to the specific details, I'll refer that to Fire and Rescue unless our officials have anything further to add. But
from a safe work perspective,
I'd have to take that on notice.
Okay.
I want to get you a comprehensive response.
Thank you. In previous estimates, we've discussed the legal case between the Rural Fire Service, aviation provider Coulson, and the widows of US pilots killed during the large air tanker crash of 2020. According to recent media, the 10-day hearing's been set down for June next year. What costs to date has the government provided for legal costs via the Treasury Management Funds?
I don't have that with me, but I'm happy to take that on notice.
Mm-hmm. And if negligence on the part of the RFS and or the aviation provider is demonstrated, what impacts would that case likely have on our international procurement arrangements?
Yeah, I'll have to get that on notice.
Is there anyone that can speak to any of that in the meantime?
we'll
Particularly
take it on notice.
the court, the legal fees?
We'll take that on notice.
Thank you. Give me 1 second. Minister, just coming back on that date rationalisation conversation we were having in the last round. So Mr. Wesling confirmed that iCare does a practice of date rationalisation, which is shortening policy periods to suit iCare's reporting and billing preferences, and that can have an impact on the real premiums paid by employers. Are you aware that Section 155A of the Workers' Compensation Act requires policies to run for 12 months? And if so, are you concerned that iCare may be acting illegally in this regard?
Look, when you, in terms of making that statement, I mean, that's a big statement to make. I have full confidence in our officials, and they are governed by their legal obligations, and they deal with some very important, comprehensive decisions. So I don't accept that word, but like we said earlier, we're happy to take that and come back to you.
Okay. Just coming back on that 55% reduction in the budget to the Dust Diseases Authority, has anyone been able to look that up in the meantime as to why?
So you're saying the Dust Diseases Board?
So there's been more than a 55% reduction in distribution to the Workers' Compensation Dust Diseases Authority in the recent budget, which on the face of it, are we expecting less claims? Are we expecting, why is less been put into the Dust Diseases Authority?
Ms. Boyd, I'll have to come back to you on that. I'm just waiting for some further information.
Okay, thank you. So that was my one that was actually about the budget. Can we?
Sorry, can I? Sorry,
Yeah.
Sorry,
Yes.
Ms. Boyd. I don't want to waste your time, but you're talking about the. Are you talking about the Dust Diseases Board? Or the Dust Diseases Scheme that's managed by iCare? So where we have.
My understanding was it was to the scheme, but
okay.
for my sins, I haven't brought the actual budget with me.
That's all right. That's all right. We'll try and get you something.
Thank you.
For the afternoon, but yeah, because that's run as a specific scheme under the Dust Diseases Act, and so you've got a nominated number of employers who pay into the scheme. But let's get the information for you.
Thank you. Yeah, it could be government contributions for the levy. I'm not sure what it is.
Okay.
Sorry, the budget's not particularly transparent on its face. Okay, so can I ask, coming back to the welcome investment in safe work in the in an attempt to bring down psychosocial injuries. Are you able to tell me how many dedicated psychosocial inspectors there currently are in safe work?
I'll get you that figure, but I can inform the committee, I can report to the committee and to the people of New South Wales that the New South Wales government will meet its ILO obligations with respect to one inspector for every 10,000 workers. That is something that I know that injured workers, that advocates, the union movement, even business community have been calling for. So with the recent injection of historic amount into safe work and with some reorganising a number of years ago, we have increased the number of our inspectors, their capability in particular, and particularly in meeting our regulatory priorities with respect to falls from height, psychosocial harms, farm safety, chemical and hazard risks. One of the things, and particularly with the rise in psychosocial hazard and harm, one of the things is making sure that we have capability within safe work, and with respect to the operations, Commissioner Scorer will be able to elaborate further. But we will have 20 psychosocial inspectors who are who've got the capability, right? Who've got the background, who understand these type of matters. So I'm really, really pleased about that. And I know that there's been all our inspectors go through thorough training. I'll leave that for the Commissioner. We also will invest in a psychosocial advisory, an advisory call centre.
Mm-hmm.
So we're expecting about 25,000 workers a year who'll be calling in and seeking either referral or support. We're working through the details of that advisory scheme. As you know, Miss Boyd, that we also have the Respect at Work unit and program within Safe Work New South Wales. It did start under the previous government. We have expanded, and we've obviously kept it going. It's very important. We've got an advisory council that has Minister Harrison and myself sit on, and a number of academics, unions, business. So we are really investing in the prevention in terms of psychosocial harms in the workplace. iCare have also got a really good program, and it did start under the former government, and some really good work is happening with respect to co-design in the community care sector, in health as well. Something that I'm looking at more intently and working with key organisations and stakeholders, because as you know, in the care sector, it's not a 9 to 5. It's not 9 to 5. You know, we've got home care workers who are tending to people with very demanding, complex needs, you know, and it can cause distress in some cases. We have incredible professionals who work in the care sector and in health, but we need to provide the support right in their workplace. So that's we're doing a lot of work in that preventative and early intervention
You'd expect
space.
all of that great investment in prevention to reduce the percentage of claims going forward?
I believe that we this hasn't happened. So this is what has been put to the government. This is what was put to me in opposition, that we need to have early intervention strategies, and we need to stop bullying in the workplace. And that's what we're doing. And we're also reviewing work within public service with respect to these policies. But this is why we've expanded the jurisdiction around bullying and harassment in the IRC.
Just back to the question then, because you said that there will be 20 dedicated psychosocial inspectors. How many are there currently?
In total? How many inspectors in total?
No, dedicated psychosocial inspectors.
20.
20 at the moment.
There will be.
What are there at the moment?
So we currently have 8 specialist psychosocial inspectors. I guess what I would say though is that our inspector workforce, whether they're construction specialists or healthcare specialists, undertake psychosocial risk assessments because of the volume of the sector. So all inspectors are equipped with the right tools to undertake those sorts of risk assessments, but there are the specialists who provide that additional support.
Thank you.
Thank you, Ms. Scora. Mr. Tudor-Hope, you've got a minute and a half.
In your earlier evidence, Minister, you mentioned that you meet with injured workers. You recall saying that?
Yes.
In relation to those injured workers, how many of those injured workers have expressed their support for the lifting of the threshold to 31%?
Mr. Tudor-Hope, you know very well, and people know very well, that injured workers have concerns about the current
Have any
bill.
indicated their support for increasing the whole of person impairment to 31% for continuing claims?
Mr. Tudor-Hope, I've had a lot more experience with injured workers than you have, and I'm happy. And this shouldn't be. You don't have a monopoly on injured workers, okay? No. So I've spent my entire adult life representing injured workers. So I'm not going to be. I'm sorry. You've Johnny come lately, right? Now, why don't you listen to your constituency and your base, who are telling us they're not happy with the Liberal Party, the modern Liberal Party? What do you support?
Thank you, Minister. Ms. Boyd, you have a minute.
Oh, thank you. iCare's claimed that the new remuneration structure for claims service providers is expected to drive a $4.5 billion claims valuation benefit to the scheme over the next 10 years. Does that remain iCare's expected impact?
Ms. Appler, did you want to, or Mr. Wessling?
Yes, it
Yep.
does. But it's not just the remuneration model that you've just attributing that benefit to. It's all the changes we're making to case management, the claims
Okay.
model. The remuneration is part of that.
And has that assumption been incorporated into the scheme's liability estimates?
I think, as we've said before, it's factored into our forward capital and business plans. Those benefits will be factored into the liability estimates as the actuaries recognise those benefits coming through.
Right, so the answer is no.
So the answer is it's not in the liabilities today. It's factored into how we calculate premiums, though.
Thank you, Mr. Wesling. Well, thank you, everyone. The time being 10:45, and in the absence of any government questions, we'll now have a half an hour recess for morning tea and reconvene at 11:15. Thank you. The time being 11:15, we will recommence the hearing. But before I do, I would just like to provide my ruling in the matter that I reserved, which was the point of order taken by Mr. Nanva. I think Mr. Nanva raised the issue of SO 63, but in actual fact, on advice from the Secretariat, it's actually SO 65 3B. Which precludes us. He was wrong, but the point remains the same. That the issue was that the disclosure or inference of how a witness was invited to give evidence before the Public Accountability and Works Committee, and this exchange did disclose private committee deliberations that have not been published by the House. So the member, Mr. Tudorhope, is reminded to be mindful of what is being said and not to disclose information that is not on the public record.
There's no suggestion that I've done that, is there?
No?
No, good.
Well...
There is, because you said that this is a government witness.
There was an inference that referred to how the person came before the committee.
Yep.
That's the key thing.
Yes.
Yep.
And that had not been published by the House. So with that, I
Well,
point of order...
I think it had been published, by the way.
Well,
because
the Secretariat, thank you, Mr. Val. The Secretariat has informed me that it has not been published. That is not recorded in the minutes that have been published in the House. So you can take that on. You can take that on notice, Mr. Tudorhope. And we are eating into your time. It's time now for your questions.
Thank
Mr.
you,
Tudorhope.
thank you, Minister.
Thank
Minister, the Industrial Secretary is answerable to you, is he not?
To myself and the Premier, you're the Industrial Relations Secretary, Mr. Secretary?
Correct, under the GSA.
Correct, thank you. So, in relation to the determination in respect to the fire employees, fire brigade employees union versus the Industrial Relations Secretary, when the Secretary contended that the Commission should award 9% wage and wage-related increase over 3 years and in the form of 3% increases effective from 26th February of each year. That was your position, was it not?
Who's the question to?
Are
Mr.
you asking
Tudorhope?
To the Minister.
To the Minister. Minister?
The government made an offer. As you know, the government made an offer to public sector workers in May of last year, and we have made changes to the Industrial Relations Commission, and we've removed the wages cap, got a new bargaining process, fire and rescue. So I'm not the employer.
Minister, the Secretary contended at paragraph 39 of the judgment.
Yep.
The Secretary contends, that's someone answerable to you.
That's right.
That the Commission should award a 9% wage and wage-related increase over 3 years in the form of 3% increases effective from the 26th February of each year. That was the position of the government and the Industrial Secretary's position, was it not?
Mr. Tudorhope, the government's offer was a baseline offer, and it was open to the agencies and unions to bargain for increases above that. In respect to fire and rescue, the parties did in fact engage in bargaining. However, at the end of the day, they were just too far apart to reach an agreement, and so the Industrial Commission was then asked to arbitrate, not just on the salaries, but on a whole range of other award matters.
Are you reading from a document, Minister?
Sorry?
Are you reading from a document?
I'm reading from a note.
Are you prepared to table that note?
It's a response note. It's my note. It's my note. So the decision...
You've got the decision in front of you?
I've got the decision in front of me.
Good, that's excellent.
And the government has welcomed the decision.
I'll go through some... did you review the reports of Ms Livingston, Mr Hewson and Ms Wilkie that according to the Commission the Secretary relied upon impressing no more than 3% per year?
Mr Tudorhope, the government makes the policy, which we did.
Did you review...
I'm not the employer.
This is my question. It's a simple question.
Hang on.
Did you review...
Order, Mr Tudorhope.
I'm trying to answer the question.
Answer. The order. The Minister was about 7 seconds into her answer. So please allow the Minister some time to answer, Mr Tudor-Hope.
Mr Tudor-Hope, the government came into office with a number of commitments with respect to industrial relations. We've made those changes. I'm not the employer. The agency secretary of the relevant agency, in this case Fire and Rescue, and through our secretary, are the employers. They've filed their evidence, and the government made an offer to public sector unions, Fire and Rescue, FBEU, gone through a process of mutual gains bargaining. They were too far apart.
Chair,
They've gone to the Commission. I'm giving you the background. Like,
I just wanted to know whether you reviewed their evidence before it was filed.
Mr Tudor-Hope, you know very well that as the Minister, I set the policy framework.
So you did.
And so the policy framework, the government, I don't interfere in processes, in operational processes. Our officials have responsibility with respect to their duties. In this case, the employer filed their evidence, and they've put forward the expert evidence.
This is not being tricky. I just ask you whether you reviewed it. If you didn't review it, just say you didn't review it.
But just to be clear, Mr Tudor-Hope, so the evidence is evidence of officials. They're providing evidence to the Commission. They certainly should not be asking the Minister to review or approve their evidence.
Well, I'm not asking to approve it, but I wonder if she reviewed it.
I'm just providing context that you wouldn't expect that the Minister would review it.
But that's not my job, is to interfere in the process.
I'm not asking you to change it.
But you have. Because, I'll...
Did you accept the proposition? Did you accept the proposition in the submission of Ms Wilkie that the real remuneration for a permanent qualified firefighter increased by 3.2% over the period from September quarter 2011 to 2023? Do you accept that proposition contained in her evidence?
Sorry, I'm just trying to understand. You're taking me through a decision.
Yep.
You're taking me through a decision.
It was a contention made by Ms Wilkie that the real remuneration for a permanent qualified firefighter increased by 3.2% over the period from September quarter 2011 to 2023.
That's Mr Tudor-Hope, if you're trying to pick at an excerpt...
I'm not. I'm just...
to try and justify the former coalition government's wages cap...
No, I'm not. I'm just asking you, do you accept that proposition?
This has gone through... I'm not interfering in a process that...
Do you accept the proposition?
What do you mean, do I accept the proposition?
That was what she submitted. Did you accept that that is correct?
That's a witness statement. We have made changes to the framework that these people are...
I'm not asking about the framework.
Did you have an arbitration in the last 12 years?
I'm not asking about the framework. I'm asking you about a proposition put forward by Ms Wilkie in her evidence. Do you accept that proposition is correct?
Mr Tudor-Hope, your government kept wages at 2.5%, and then in 2020 you had a 0%...
A point of order has been taken, Ms Saval, on a point of order.
Just around paragraph 19, the procedural fairness resolution and the lack of courtesy that's being afforded to the witness here. The Minister's been asked the same question in various ways, probably 5 or 6 times now, and she's continually interrupted as she's partway through answering. I'd just ask you to remind the Honourable Damien Tudor-Hope about the need to provide witnesses for courtesy.
It was a fairly direct question. Did she accept the proposition?
Well, yes, it is a direct question. I do believe that I don't uphold the point of order. The Minister was being relevant to the question that was asked, and proceedings are not helped when there are questions put from the witness back to the Honourable Member. If we could have questions and then some time for an answer without questions back to the committee members, that would be helpful as well. Mr Tudor-Hope.
Minister, I'm not asking you a trick question. I'm just asking you that it was a proposition put by Ms Wilkie. Do you accept that that is correct? Yes or no?
Mr Tudor-Hope, you've got to understand this in context. This is the first arbitration for a very long time, as you know. Now, you didn't have these arbitrations under your government. After 12 years of a wages cap, a decision has been a decision of the Industrial Relations full bench has been handed down with respect to firefighters. Now, you're asking me to make comment on an excerpt about one of the experts, but in what context? I'm not here
Minister,
to justify.
I'll move on.
But I'm not here to justify.
I'm asking you
your
direct
government.
questions. If you
Do you
can't
still
answer
support a
direct
wages
questions, then
cap?
that's fine.
Do you still support a wages cap?
Order, Minister. As I just previously guided you, it does not help proceedings for you to be asking questions of the honourable member.
I apologise, Chair.
So if we could avoid that, we could have questions from the committee members and answers from yourself.
Minister, can I take you to paragraph 89 of the judgment which you have in front of you?
Yep. Yep.
You'll see there that the Secretary responded by contending that were the Commission to go back in time to a datum point before 2023, it would go further back than 2020 and have regard to a period since 2011 when the wages cap was introduced, or indeed back to 2008 when the two awards were last reviewed on work value grounds. That is because there were sustained periods of real wage growth before 2020 which offset the fall in real wages in the period 21-22. You see that there?
Yeah.
Yes, good. Did you raise any objection to the Secretary making this contention, or does it reflect the view of the government that real wages for firefighters have increased since 2011?
Mr. Tudor-Hope, look, we welcome the decision.
Good,
the full
thank you.
bench of the Commission, we welcome the decision, and it was your government that kept wages low. You didn't have a bargaining framework, and you legislated the wages cap. You legislated, and it was very difficult for the Industrial Relations Commission to do its work unfettered. And so there is now a process. They've gone through a process, and we welcome the decision.
Good, thank you. If you go to paragraphs 19 and 20 of the decision, Minister, the Commission was very critical of the Secretary for pressing about 30 claims for textual changes to the award without making any submission on any of those claims, stating that this approach by the Secretary, and I quote, is to be deprecated. It would have been much better if the parties had taken a more forensic and discerning approach to their claims, reducing what needed to be determined. Had that occurred, our decision would have been considered in a considerably shorter and handed down much earlier. This is a serious criticism I'm putting to you, Minister. Why did you allow the Secretary to press claims without any supporting submissions, thereby creating unnecessary work for the Commission to do and delaying not just the decision but the ongoing work of the Commission?
Mr. Tudor-Hope, you're cherry-picking parts of the decision that you have to look at
This
holistically.
is the only two paragraphs which dealt with this issue.
No, but you have to look at this holistically, that under your government you kept a wages cap and you didn't negotiate with the workforce, and this is why we're left in a situation where there were 80 or so claims that were put forward by the FBU and a series that were put forward by the government. And if you read the decision and if you read the what the FBU have putting forward, is that for a very long time we know that their work has changed. We know that the demand on firefighting has changed. And so this government has taken what they have said very, very seriously, and there are a number of investments that have been made. But with respect to their wages, the government, as you know, and this has been said in the public domain, that, and I do acknowledge Fire and Rescue and the FBU for the considered work that they did, and I acknowledge the FBU's work. It was very thorough, very considered, but this is work that your government didn't do. This is a lot of work that was left behind for us to look at.
I just pointed out to you.
You've pointed out something. You've pointed out something, but you're trying to make a point where I'm saying to you that there's a lot of work that needed to be done over the last decade. Change work practices. have changed in this area, and so this has been acknowledged in this decision.
So, I think
Sorry,
I
Secretary.
should clarify that we don't and we didn't seek the Minister's approval for the submissions that we make in this regard. We act independently in that respect. And also just comment, I mean, you've characterised as a criticism of the Industrial Relations Secretary. It's actually commentary by the Commission on both parties, on the FBU and the government, having the potential to have done more to reconcile some of those positions before coming to arbitration.
With respect, Mr. Draper, I think that's your opinion.
No,
I think most people reasonably
it's quite
reading
clear.
that.
Any plain reading of those paragraphs above the ones you pointed out make that very clear.
Well, I'll refer you to a conclusion that he reached at the conclusion of his report of the judgment, Mr. Draper, which in fact sheets home the criticism, in fact, to the Secretary.
Well, I'm just referring to the ones that you've pointed out to us.
Thank you. There is, you'll recall that there is, that we passed the Industrial Relations and Other Legislation Amendment Workplace Protections Act 2025, I think earlier this year. When will that act be proclaimed, Minister?
Thank you. Thank you, Mr. Tudorhope. I appreciate that question. That's a very important question. As you know, that there were a number of changes that have been introduced with respect to Industrial Relations Act, and particularly the Industrial Relations Commission. If I can take you to setting up the anti-bullying and anti-sexual harassment jurisdiction, because these are new in the Commission, they've obviously had to do work around practice notes, forms, and my understanding, and this has been brought to my attention, that it's not as easy. So setting up, for example, when you go and file an unfair dismissal application, you've got your application there. It's very simple, very black and white. With respect to applications around filing an application with respect to a stop bullying order.
I'm aware of what the Act contains. I just asked you when it was going to be proclaimed.
Mr. Tudorhope, and I'm saying this to you and to the committee, I don't have a date for you.
Thank you. Well, it contains as an important provision, an object of the Act, to in fact empower the Commission to eliminate gender-based undervaluation of work.
That's right.
You
Mr.
recall
Tudorhope.
that has been included?
That's right. That's
well,
right. Of course.
Will that provision be in place in time for the Commission to eliminate gender-based undervaluation of work in determining the new nurses and midwives claim?
Mr. Tudorhope, terrific question. And with respect to a date, I don't have a date, but I know that officials are working feverishly to make sure that we get this right. And I want to explain that there are some privacy aspects here with respect to the anti-bullying application. So put that aside. With respect to the objects that you've raised, they'll be proclaimed at pretty much the same time. With respect to the nurses' case are running. They're running through the current award-making principles with respect to gender undervaluation.
Will you be making the same submission in relation to the nurses' claim as you've made in relation to the Fire Brigade Employees Union claim, that the increase should only be 3%?
Mr. Tudorhope, look, I don't want to be sarcastic about this, but it's quite interesting that you're standing up for working people in opposition. It's a shame you didn't do it when you were in government. And we had
just
to
answer
support.
My question.
No, we had to support over 1,200 nurses.
Just
who
answer my
weren't going to
question.
be. They were COVID nurses who weren't. You didn't have money in the budget.
I said,
with respect to evidence,
making
I don't interfere in that process.
Well,
that's the Health Secretary.
Let me ask you this. The Premier and the Minister for Health have repeatedly insisted that safe staffing levels have been put in place, and in those circumstances, the Nurses and Midwives Union should not expect a pay rise higher than 3% per year. Is that your position?
I refer you to the statement of the Premier and the Minister for Health. We have worked very hard And the Minister for Health has worked very hard with the Nurses and Midwives Association with respect to safe staffing levels. Now, these are policies that your government didn't undertake. We've had incredible we have had enormous vacancies, and it was your government that left us with supporting the 1,200 or so nurses. There is an arbitration that is going to start at the end of September, and I have nothing further to add. I'm not going to prejudice this case.
Well,
I'm not going to prejudice this case. And with respect to, I think that...
Order, Mr Tudor-Hope. The Minister... Order, Mr Tudor-Hope. No, I don't think the Minister had finished. The Minister... If you could please continue. Finalise your answer. Thank you.
Minister, one of the provisions that the Commission relied on the Fire Brigade Employees Union case was in fact that because of the decision made by the Industrial Relations Commission, there had been a reliance on a prediction in relation to inflation which was in error, and for that reason they awarded the Fire Brigade Employees Union an additional 2% increase in relation to that award. Would you be including that additional 2%, which has now been found by the Industrial Relations Commission, in the offer being made to the nurses and midwives?
Mr Tudor-Hope, every case is based on the principles and is based on the legal framework. Every case, the firefighters' case, the nurses and midwives' case, are very different. And so I have nothing further to add.
Well, you're now aware of what the Commission has found. And perhaps I ought to put this to you, Ms Rizzo. Will you be including that material as part of the submission to be made in relation to the nurses and midwives?
Mr Tudor-Hope, what material? Sorry, just to clarify your question, do you mean that the 2% increase?
Correct.
That's not a decision for me to make. It has a potential to be a precedent risk, but it would not be good practice to simply apply all outcomes of the Industrial Relations Commission decision to any arbitration that is pending. It just doesn't work that way.
But certainly the precedent risks, as you identify, exists, and it's a fairly forcible argument to be made out that 2% would apply.
Member is now asking questions that stray into a very hypothetical nature. Questions to public servants. I can't remember the standing order off the top of my head, but should be factual in nature. I think it's Procedural Fairness Resolution, paragraph 10. Questions should be factual in nature and should not ask public servants to express opinions on the merits of policies of the government of the day.
To that point of order, the member's question was directly based on seeking elucidation of something that had been given in evidence by the person to whom the question was addressed.
Further to the point of order, Chair, the preamble to the question was would that, which suggests that the Honourable Damien Tudor-Hope is seeking an expression of an opinion on a hypothetical matter from a public servant, which I think is out of order. You can put it to the Minister, but not to a single public servant.
To the point of order, the witness identified the precedent risk which is relied upon, which underpins the question.
Yes, I do uphold the point of it. It was framed in the context of a hypothetical, which is we are to avoid when we're asking questions of our public officials. Now it's time for questions from the crossbench.
Thank you very much, Chair. Minister, as a general rule, would you agree that workers should be on an award or an agreement of some sort?
Of course, yeah.
Has the PSA written to you about the MOPS Act and union members' request to be covered by an award or an agreement?
I am familiar with their advocacy.
Have they written to you?
I'll get back to you on that. But I am aware of union members' advocacy with respect to the MOPS. Yep.
And is this something that you have been considering in your position as Industrial Relations Minister?
I look at every matter, and more importantly, and this is a matter of importance, but more importantly is that under Premier Minns and our government, we are close to 90% of achieving agreements with our public sector workforce. That's a major achievement, and this is multi-year agreements, and this is working through our framework, our new bargaining framework.
Yeah.
And we have seen, even just recently, where we saw health workers get an 8.5%, cleaners, security guards.
None of that's comforting, though, if you're a member of Parliament staff. So when it comes to members of Parliament staff, at the moment, they are subjected to quite a, what some would say was a worker-unfriendly bit of legislation. They are, or at least some, are asking for the MOPS Act to either be modified or scrapped to allow them to also have an award or an agreement so they can bargain for better pay and conditions. Is that something you support?
I have enormous respect for parliamentary staff and staffers. They do extraordinary work in keeping our parliament in doing the work that they do. They keep our democracy robust and, of course, accessible to the people. I have enormous respect for parliamentary staff, and like many things that are put forward to me, I consider it on its merit and through a process. Now, I understand that parliamentary staff have been advocate. I know that, so happy to meet with them.
Are you aware that the New South Wales position in relation to members of Parliament staff is quite different to the other states and territories and the Commonwealth?
If you say that.
Yeah, sure. They have...
I'm focused on the people of New South Wales, so...
Yeah, including people who work in... Yes,
absolutely.
In our parliaments. In a parliament. On the 29th of May of this year, there was a landmark case that ruled against the State of New South Wales. It's got Ashton and State of New South Wales. This was a full bench of the Industrial Relations Commission confirmed that employees under the MOPS Act can bring proceedings for relief from victimisation under Section 213 of the Industrial Relations Act. So although they don't have the full suite of rights that other public servants do, they under this full bench ruling, it was determined that staff can at least bring proceedings for relief from victimisation under Section 213 of the IR Act. The state is appealing that, though. Why is your government appealing that case and that ruling?
Miss Boyd, as the matter is before the court, I'll refer that to you to Miss Rizzo or Miss Dobbins.
So we haven't had a chance to read the judgment, Miss Boyd, but I understand the Court of Appeal has overturned the full bench's decision this morning.
This morning?
That's the only information I had. I'm sorry,
Okay.
because I'm in here, but that's my understanding. Yes.
Be interesting to know why the government thought fit to seek that relief in the first place, though.
I think that is a question for the Minister and the Government, but I'm just saying factually the Court of Appeals overturned the full bench decision.
Right. Well, perhaps that, Minister, that sort of underlines the reason why members of Parliament staff need more rights than they currently have. Can I leave it with you to
absolutely
actually
Of
investigate
course, Ms. Boyd.
further?
Yes, and as Ms. Dobbins indicated that decision's been made, we will look at that decision, of course, and my door is open and I'm happy to speak to the delegates, and I speak to the PSA all the time, but and we'll be looking at that decision.
Do you think that members of Parliament staff should have some form of protection from victimisation and unfair dismissal?
Ms Boyd, as this matter, if you're referring to a particular matter...
In general. I mean, they don't have it under the MOPS Act. I haven't read this judgment either. It appears they don't have it under the IR Act either. Is that really a position that should stand, given that in New South Wales we have woefully inadequate protection for our staff compared to other jurisdictions? Is this something that your government would seek to modernise?
Ms Boyd, I will take advice. Obviously this decision's been handed down just a little while ago and I will take that on notice, but of course we absolutely value the parliamentary staff and the important work they do, and I hear what you and others have raised with me with respect to Parliament staff.
If I could go back to those the questions I had before about the psychosocial inspectors. I understand that there was previously a dedicated team of psychosocial inspectors in Safe Work a few years ago, but that team was disbanded following a restructure. Do we know the reasons for why that was the case?
I couldn't speak to the historical reasons, Ms Boyd, but what I would say is that is certainly a function that is being rebuilt with this iteration of Safe Work. So both in terms of having a dedicated psychosocial expertise across our inspectorate, dedicated inspectors, as well as the Minister has said before, the advisory service that is a broader support program for businesses to get advice. So something's being rebuilt, but I couldn't speak to the history of why it was not continued.
So, yeah, okay. Because I understand that there was a dedicated team that then got absorbed into sort of the general sort of inspectorate team. Is the new proposal now that they're going to sit separately as a distinct team again?
There will be some distinct team, but I think, as I mentioned before, with what will be, once we have the full recruitment of our new inspectors, about 470 inspectors, to get the breadth of reach around this particular harm, we want all of our inspectors to have the skills and capacity to recognise even at a very basic level where there might be psychosocial harms that we need to do some further work on, and that might be then when you bring in someone who's got a particular expertise as an inspector, or you get a particular bit of advice about how to handle it. So definitely trying to broaden out what we do with psychosocial harms.
So, okay, so 20 dedicated inspectors out of 470, but you say that you're trying to expand the level of expertise around psychosocial safety generally.
That's correct, yes.
How is that being achieved?
So part of that goes to some of the tools and programs internally. So, you know, for example, an inspector who goes out to a construction site might have a particular expertise around that sort of industry, but needs to also be able to have a conversation and have the skills to be able to have what can be tricky conversations about sexual harassment or about bullying, those sorts of things with the relevant PCBU. So that's partly how do we give our inspectors the tools, as well as enhancements in training and support that will come both from in-house but also from the enhanced function that we are building within Safe Work.
Minister, Ms Scorer raises an important issue that I think we've spoken about in the past as well, but during within the construction industry there is quite a pronounced risk of psychosocial harm. Yes. What is your government doing specifically? And I note in the context of obviously the issues that we've had around the CFMEU going into administration, the concerns we've had that the safety concerns were not being raised in the same way that they used to be, and all of that.
Yes.
What has your government done to actively increase psychosocial safety in the construction industry?
Yes. You raise a very important question, and I can report to you and to the committee that We'll be organising a roundtable with construction and building industry heads, the building trade unions, including the CFMEU administration, and experts with respect to psychosocial harms in the workplace. The two organisations, Founder House and Mates in Construction and others, will be holding a roundtable because I'm very, very concerned about the increase in psychosocial risk in construction for construction workers. I am also very concerned about the high number of falls from heights with respect to young workers in particular. And I've seen this, I mean, the reports that come in, either I see, seriously injured young workers who are working in the either T3 or T4 small your mum and dad operations where you've got a father and son operation, and you've got the young man. Unfortunately, we've had a few of these cases in the last few years where the young apprentice, the young labourer, is killed or seriously injured. I'm very concerned about that. I know we're all concerned about that. So we're holding that roundtable. It's been brought to my attention by the bosses, by some of the bosses around their concern around the mental health and the psychosocial, the mental health of their workers. They want to work together, and this is something that we all agree that we need to do more work, and government will organise that. Happy to let all of you know when we're going to set that up. I'd like this to be ongoing, but this is really, you're absolutely right, and this is something that has been concerning me for a while, and I know others as well. As Commissioner said earlier, with respect to inspectors going out onto work sites and working together with organisers from the CFMEU administration, look, that is happening. That will continue to happen where government can provide additional resources, attend sites through request for service processes. And I know that recently there have been a number of incidents where both the government and organisers working together. So that will continue to happen. But I am very concerned about the psychosocial concerns that you have for the construction industry.
Thank you. Do you know how many work-related deaths have been recorded in New South Wales in 2024 and so far in 2025, and how that compares with previous years?
I understand. I'll get the correct number. I understand that there has been an increase.
There have been 52 work-related deaths so far this year.
This year?
Yeah.
What was last year?
60.
Right, okay. Do you have a breakdown of sort of how they sit across industries?
I can provide that for you on notice, that's fine.
Thank you. What was the 2023 number? That's quite concerning, that 52.
I'd have to take that on notice to be reliable.
Yeah, okay.
Yeah.
Thank you. Can I ask how many psychosocial prosecutions Safe Work has brought in the 3 years since the positive psychosocial duty was introduced in 2022?
I'm happy to provide that for you on notice, Ms. Boyd.
Okay, maybe come back this afternoon.
If we can, we will, yeah.
On that. How many prosecutions has Safe Work brought against New South Wales Health in the last 10 years?
10 years, I'll have to definitely have to take that on notice.
Are you able to tell me some more recent data for now? Or is there...
I'll just need to find my note. I'm happy to come back to it this afternoon if you like.
Do we have any visibility over work-related suicides?
Not as a unique data set, I don't think, but I'm happy to see what we can find for this afternoon, yes.
Thank you. I understand that under the way that we capture workplace deaths, we're not capturing suicides quite expressly. I think it's interesting. We often get sort of questions about the interaction with the new industrial manslaughter laws
Yeah.
and how they apply,
Yeah.
where something is could be traced back to a particular, psychosocial injury and how that then plays out. How do we capture that information, or do we just not capture it at all?
I'll have to come back to you with our data on
Okay.
whether suicide in particular is recorded as a workplace death. I think that's what
Thank you. Just a random one, but can you provide an organisation chart for the new independent safe work and what that looks like?
I'm sure we can on
Yeah,
those, yes.
Thank you. Has Safe Work conducted any proactive audits of seasonal worker housing and living conditions? It's another one that we get a lot of questions
Yes.
to my office about.
Yes, we have, yes.
How many audits have you done?
I have to get the number for you, but I'm happy to provide that on notice.
And has any sort of prosecutions or anything arisen out of those audits?
I can't recall any prosecutions, but we'll for this year, but we'll come back to you.
Okay, thank you. Is there or whether there is other enforcement as well, any other kind of enforcement
Any other
actions
enforcement,
coming
yeah,
out
we
of
can
that?
come back to you.
That would be useful to see. I've got 2 minutes left. I think I'll pause there, but I will come back in the next round.
Can I
Yeah.
just, that with the, that information that you've sought around the statistics, we're also making changes through the, when we brought the legislation to the Parliament about the the standalone agency.
Yes.
We have included a number of provisions about the sort of the openness and transparency and accountability with respect to stats and that information.
Yeah, okay.
So, just letting you know.
Good.
Yep.
Thank you. How many safe work inspections were conducted in, you're going to take this on notice, but I'm going to ask anyway, were conducted in warehouses, fulfilment centres or distribution hubs in the last year?
I will take that on notice.
Great, thank you. Are there any reviews underway in safe work in relation to, where the inspectorate sits or anything else? Any sort of general reviews underway at the moment in safe work?
We do have a review being undertaken, which is really an internal review to identify what is the best utilisation of the additional investment that government has made. So there was the work done before the 1st of July to establish us as a standalone organisation. And then the next piece of work is quite a quick piece of work to really, what is the best way for us, particularly as you've asked about before in terms of the psychosocial investment, what is the best way for us to make the best use of that within our new structure? So that is really a bit of internal business process review, but that's the only review that I'm aware of being undertaken currently.
Are you able to give us the terms of reference for that review?
I'll take that on notice. Yes, I'll take that on notice.
Okay.
When I say review, it's a consultancy firm that's doing, a small consultancy firm that's doing that, so it's not a review as you would say. But in the interest of transparency, we have someone who's doing work with us to review our business processes.
Does it cover the potential for job cuts?
No, that is certainly not the point of the review. We're in the what I would say is the blessed state of having to expand. So what's the best way to expand? That's really the question that we're asking ourselves.
So not total job cuts, but in terms of cuts to particular...
It's more about is the role doing the right thing in the right way rather than cutting jobs. So there might be some, we need you to go over there sort of thing rather than us looking at cutting jobs.
But not letting people go.
That's not the intention, no.
All right. Okay, and do you expect certain specialist areas to be reduced?
I would. That's not the first intention. No, it's really, are they in the right part of the structure? Do they have the right business system processes to deliver what's been asked of us as an independent agency?
Thank you.
Thank you, Ms. Boyd. Thank you, Ms. Scorer. Mr. Tudorhope.
Minister, are you aware that a fire drill, of a fire drill that occurred at the Safe Work office on the Central Coast in August this year?
I'll refer it to the Commissioner.
I'm not aware of that, no.
Well, then in that case you're probably unable to tell me whether it was a success, but it could be a concern to you, Commissioner, that you conducted a fire drill at a safe work office, and in the course of that fire drill the employees couldn't leave the building because the door leading from the building was stuck and made the building inaccessible?
Yes, that would concern me, but I don't know any more detail about it, so I'll need to look further into that incident.
Thank you. I'll hand to Mr. Carter.
Okay. Good morning, Minister.
Good morning.
Minister, if women were regularly experiencing sexual harassment or discrimination based on their sex at their place of work, would this be an appropriate matter for a safe work investigation?
Without getting into the details, because I know that in terms of matters, particular matters, I know that there's kind of a rule around the privacy, but of course the safe work inspectors will get a request for service and they'll make an assessment, but I'm happy to refer you to the Commissioner with respect to an operational matter.
Further questions in the afternoon. No, it's if these same women were regularly experiencing discrimination on the basis of their race at their place of work, would that be an appropriate matter for a safe work investigation?
Are you referring to the Sydney University matter?
I will come to that, but I'm referring to the general
Don't
principle.
pepper me with questions. This is a very serious matter. So
I
get
agree.
straight
It's
to
a very
it is a very serious matter.
Minister,
so get to the
I
point.
have, Minister.
Minister, the honourable member is entitled to ask the questions that she sees fit. So, Mrs. Carter, you're free to do so.
Thank you. Minister, I don't think it's a difficult or a tricky question. If women were experiencing harassment at work based on their race, should they be able to bring that matter to safe work, especially if that is creating a psychosocial hazard in their workplace?
Ms. Carter, the government has zero tolerance for any bullying or harassment in any workplace in New South Wales. And for any worker, they have absolute right to get in contact with Safe Work to raise those issues. But at the same time, every single boss in this state is covered by the Work Health and Safety Act. And they have an obligation, they have duties under Section 19 to make sure that they follow the duties. We as a regulator regulate, and we will do what we have to do and work in whether we have to issue penalties, whether we go to court, but those are operational matters that the Commissioner can ventilate further. But no, I do not tolerate. There is no tolerance for bullying or harassment in the workplace.
So you would not support the proposal from Safe Work New South Wales that psychosocial hazards created by racial discrimination will not be investigated by them, but referred instead to the Australian Human Rights Commission. Is that the case, Minister?
My understanding, and I want to be absolutely correct, I understand that this matter has been investigated.
Minister, with respect, we're talking about matters flowing from that investigation at the University of Sydney. And one of the matters flowing from that is that there has been a recommendation in an inspector's practice note that psychosocial hazards created by racial discrimination will not be investigated by Safe Work, but rather referred to the Australian Human Rights Commission. Do you agree with that proposal?
No, Ms. Carter, I know what you're referring to, and there is absolutely no tolerance for bullying and harassment in the workplace. I understand where you're getting to, and with respect to the operational matters, there is a process, and I'll refer you to that.
As a matter of policy, Minister, do you believe that racial discrimination that creates a psychosocial hazard should be treated differently than sexual discrimination that creates a psychosocial hazard?
When you're talking about racial discrimination, let me take you back to the amendments that you're putting up that are going to impact workers with respect
Minister,
to workers' compensation. I'm asking.
Minister, I'm asking you not
No,
about
you
what the
can't-
law might be, but
I know
about
what you're
the
trying
law
to do
is
here.
now.
This is a very, very serious matter.
I agree.
That you have brought to the committee, and I take this very, very seriously. And there is no
Minister,
place.
I would appreciate a
there is-
serious answer to the important question I have asked you.
The regulator, I will refer you to the regulator with respect to the operational matter and the decision making that they got to. With respect to a policy matter, nobody should be discriminated in the workplace for race, sex, or other matters. Absolutely not. However, the workplace has a responsibility to keep workers safe. It is the boss's responsibility to keep workers safe in the workplace. It is the regulator to make sure that that is happening. Now, the workers have gone to Safe Work and they've put forward a request for service.
Can I ask you a question about that? I entirely agree. It is the boss's responsibility to keep
Absolutely.
workers safe. And so therefore, should workers who feel that they are unsafe because their bosses have not made a safe place of work, should workers who feel they are unsafe because of repeated and consistent acts of, as in the example of the University of Sydney, 11 months daily experience of anti-Semitism, should those workers have a right, if that happened today, to go to Safe Work New South Wales?
Ms Carter, the government and all of us agree there is zero tolerance for anti-Semitism. Absolutely zero tolerance. Now, I understand that this matter has been brought forward to Safe Work, and there has been work that has been done between Safe Work and the University of Sydney. With respect to the specifics, I'll refer you to the Commissioner.
Minister, are you aware of the Inspector's practice note flowing from that investigation at the University of Sydney, which seeks a change of policy that psychosocial hazards created by racial discrimination go to the Australian Human Rights Commission rather than Safe Work? Do you agree with that policy?
Ms Carter, I will take my advice from the Commissioner and I refer you to the Commissioner. Ms Scorer, can you please assist?
So do you agree that psychosocial hazards created by racial discrimination should be treated differently to psychosocial hazards created by sexual discrimination?
I would say that all harms that relate to psychosocial injury should be assessed by Safe Work. So whether that, as you're pointing out, whether that's sexual harassment, racial, etc. What I would say in terms of the file note, these are contemporaneous notes that our inspectors take at the time.
Excuse me, we're not talking about the workbook, we're not talking about the file note, we're talking about an inspector's practice note, we're talking about a request to change policy. And I would just really like a really clear answer. A racial discrimination complaint made today, does that go and is that investigated by Safe Work or is it flicked off to the Human Rights Commission?
That would be investigated by Safe Work.
So it will be investigated by
Point
Safe
of
Work.
order has been taken by Ms Saval. Ms Saval, on point of order.
In relation to this line of questioning, as Mrs Carter's identified, the line of questioning is in relation to a potential or hypothetical change in government policy. That being the case, the questions should either be to the Minister or, perhaps reframed so that they fall within the ambit of the Procedural Fairness Resolution, paragraph 10, which requires that public servants be not asked to express opinions on a matter of public policy.
I'm not going to uphold the point of order because I don't think it was a hypothetical. I think Mrs Carter was referring to a practice note that sought a change. I'm relying on her integrity there. That is actually what has happened, and she did put the question both to the Minister and was referred to the Commissioner. So I don't think it was a hypothetical, so I don't uphold the point of order.
Thank you. Minister, with respect to the Inspector's report of the events that occurred at the University of Sydney, that Inspector is reported as requesting a full investigation and with the likelihood that criminal matters may lie as the result of a further investigation. The independent decision-making panel, however, is reported as having declined to accept that recommendation without giving reasons. have you implemented the changes recommended by the McDougall review in respect of independent decision-making panels?
Ms Carter, with respect to the IDMP, and I know that in opposition, when I was the Shadow Minister, I had grave concerns about the IDMP. You've got to remember that the Safe Work is a standalone regulator now. Lots of changes have been made.
Minister, with respect, I'm asking about a time before it was a standalone regulator, while it was under your responsibility.
The IDMP, there have been changes made, and the government, and through Safe Work, have fulfilled close to 22, 23 of McDougall's recommendations of the 46. One of those is the change with respect to the IDMP. There has been a change because I agree that we now have a lawyer, and there has been a change of the makeup of that panel. So I'll leave it at that. But that recommendation has been implemented.
This was a very significant investigation over a psychosocial hazard that existed over a period of 11 months, yet no reasons were given for the IMDP's decision not to proceed. Are you happy that very significant matters like that, no reasons are given?
Look, Ms Carter, this is a very serious matter, and this is a panel that existed under the former government. McDougall
Minister,
made a number of recommendations
while it was on your watch.
McDougall made a number of recommendations. We have implemented McDougall's recommendations with respect to Safe Work should give consideration to establishing a policy that wherever possible, the IDMP, the membership, that panel has changed in terms of at least one legal practitioner with relevant experience in the area of workplace health and safety law in prosecutions for breach of obligations under that law. Simplifying the paperwork.
If I could take you to something specific. So the Safe Work investigation at University of Sydney, recommendation for investigation and prosecution, that recommendation declined without any reasons given. Yet in the inspector's practice note, which is seeking a change, it points to the fact that investigations involving racial discrimination are resource intensive. Does Safe Work, or did Safe Work at the time this was happening, have sufficient resources to be able to follow through for the safety of those workers at the University of Sydney?
With respect to the operational and assessment process, I'll refer you to Dr. Casey and the Commissioner with respect to that process and what has happened after, because
it's not a process question, Minister, it's a resources question.
We've resourced...
Did Safe Work at the time of that complaint being made, was lack of resources the reason that did not proceed to a full investigation?
This is a really serious matter, and it's our government that's invested $127 million in resourcing Safe Work New South Wales, whereas Safe Work under your government was part of a regulatory unit, and it was shackled. Now, with respect to this, is what you've brought forward is very serious. I am very aware, and I have put forward my statement.
Okay, thank you, Minister.
Do you have anything further?
Minister, I'll come back this afternoon if that's okay.
Sure.
Can we go to recommendation 15 of the McDougall review? How many inspectors have now had specific psychosocial training, and what further training is scheduled for this year?
I'll refer you to the Commissioner.
Okay, I'll pick that up this afternoon. Minister, how much money has been spent on the initial rollout of body-worn cameras for inspectors before enabling legislation was in place?
announced that inspectors will have their body-worn cameras. We announced that a few months ago. There was a trial.
Mm-hmm.
What are you asking for? The cost?
Yeah.
I don't have that. I'll get it for you.
All right.
I'll
Thank you
get
very
it
much.
for you.
Thank you.
Can we get?
Thank you, Minister.
Can we get that?
Perhaps while that's happening, we can talk about safe work targets. What outcomes is safe work targeting in 2025-26 to judge their effectiveness as a standalone regulator?
Excuse me, Ms. Carter, can you repeat that?
Sure. What outcomes are safe work targeting in 2025-26 to judge its effectiveness as a standalone regulator?
Well, we've got a new act.
And
So-
how are we going to judge the effectiveness, Minister?
Well, we're going to make sure that, particularly with the additional resources that this government has provided, with the additional inspectors, working through our task force, working through our advisory council, that there will be, what I'd like to see is improvements, particularly in those regulatory priorities. But with respect to targets or performance measures, is that what you're...
I'm asking, Minister, how we're going to measure the effectiveness of safe work. For example, what measurements have been taken since 1st of July so that we can get some early indication of how safe work is functioning as a standalone regulator?
Yeah, I'm happy to refer to the Commissioner on that.
With respect, Minister, I'm asking you how you as the Minister are looking at the effectiveness of safe work. I'm not asking safe work how they self-assess. I'm asking what work is being done to check how the independent regulator is working. Like, for example, is there faster first contact? Are there more prosecutions? Are there fewer repeat offenders? That's perhaps a bit early to tell.
Well,
are there any indicators that to demonstrate the effectiveness of this change?
So in July, from July 1 to July 4, we had a massive blitz across New South Wales where all our inspectors were out there. This is the first time in over a decade where we saw a massive blitz. I understand there were over 500 penalties issued, Commissioner?
Yes, that's correct.
Yeah. So, and it wasn't just construction, it was making sure that we attended work sites that requests for service had been made, repeat offenders, as you said. So that was the largest blitz in over a decade.
Thank you.
So that gives you an early indication that, number one, is you've still got businesses doing the wrong thing, and also that we'll continue to do that work.
And how much did it cost to set up Safe Work as a standalone regulator?
I'll get that for you.
Thank you. And were any consultants engaged in the process?
I'll get that for you.
Okay. And if you could, how many engagements and what the total spend on that was?
Of course.
Are there any gaps in Safe Work New South Wales regional inspector coverage?
That's a good question, and I'm sure that the Commissioner will be able to provide that additional information. I am very grateful to our regional inspectors who they've got a very they've got to travel vast lengths to get to sites. And I also want to acknowledge the work that they've been doing, particularly around farm safety. In the last couple of years, we've held a farm safety roundtable, one in Griffith and one in Orange. As you know, through the farmers, through the Country Women's Association.
These are very important.
It's really important.
Very important.
So
very
there's
important.
a lot of work that's going on. My expectation is I want to see tangibles and I want to see bespoke solutions for that sector, because it's not one size fits all.
No. How many complaints have been made against Safe Work New South Wales regarding violence and aggression towards inspectors in the last 2 years, and how are they handled?
Yeah, I am in terms of violence against our inspectors.
Yes.
I am familiar. With a number of those. I think that. Sorry, I'll rather get you a. the Commissioner will be able to provide you with that additional information, but any violence or aggressive behaviour against safe work inspectors, of course, Ms Carter, is not tolerated. There are measures in place, but this is why we introduced the body-worn cameras, for that very specific reason, because unfortunately you have some cowboys out there that don't want inspectors to come in on site. But we'll do what we can to ensure that our inspectors are protected.
Thank you, Minister. Ms Boyd.
Thank you very much, Chair. How many safe work employees are currently claiming workers' compensation?
I'll take that on notice. Did you know?
Are you going to tell me how many?
We'll get the note up. I think it's 24, but I'll clarify that for you.
How this compares to previous periods as
that,
well?
That I'll have to take on notice, yes.
Thank you. You said before, Ms Scora, was there 140 inspectors? Is that what you said, or 147? I can't remember. How many inspectors do we currently have?
We've got just under 400.
Oh, just under.
Once
Sorry,
we're,
not 140.
Once we complete the recruitment process that we're currently going through to expand the inspectorate, it'll be 479.
479. Okay.
469, sorry.
And how many of them are actually going out and sort of in workplaces versus how many sit sort of and have more of an administrative function?
Well, I mean, the inspectorate is people who go out. That's what.
So they all are?
That's largely their role, yes.
Okay.
They obviously have administration tasks to do, but effectively those are people who are out in the field.
Okay. Are there different? Sorry, excuse my ignorance, but are there different levels of like inspectors? Are there sort of field inspectors and managers, and what's that look like?
Yeah, there's sort of seniority of inspectors, there's state inspectors, and that helps with some of the triaging of requests as they come in. So a more senior inspector, if you like, who might take on more complex matters, particular instances where they need to go, where there's someone in training, where you need someone to go with those sorts of situations.
Okay. Thank you. I think we spoke last time about Safe Work doing some work around having a trauma-informed approach when it's particularly when it's going out to community services that are, for example, dealing with domestic family violence and other things. There was some suggestion that there would be work done with the Women's Safety Commissioner and others to try and put some training in place or something else. Has anything happened in relation to that?
I might ask Dr. Casey, do you know?
Yeah, look, we have done some work in that area, Ms Boyd, and we're about to, go to market to procure a trainer. So the course has been developed in consultation with those agencies that you mentioned, and a really important component of bringing on new psychosocial focused inspectors is ensuring that we've got that broad trauma informed training rolled out across Safe Work. So we have a new training package that's about to be rolled out, and I should add that over the last couple of months we've also had about 70 face-to-face psychosocial training that includes some of that vicarious trauma component rolled out to the existing inspectors. So certainly a focus for us.
Okay. Thank you. If I could just ask, 1 second. Actually, I'll come back to you, Minister. Before we were talking about this date rationalisation issue, and I was pointing out the seriousness of if this is, of course, not compliant with the law. Is that an issue that you were made aware of previously?
It was how you've brought it up to the committee, so I said that I'll get.
But were you aware personally of this previous to this committee hearing?
No.
No, you've never come across that issue. No one's raised it with you.
With respect to small businesses paying more than the large?
No, this is the date rationalisation issue. So this is where the iCare basically is, the result is that the premiums for small business increase because of the way that the period of time which the discount is applied
yes.
takes effect. So you can be paying from the beginning of the financial year, or you can have your your policy running from the beginning of the financial year, for example. But if you're a month in before you actually pay your first payment, then your first premium payment, then iCare treats it as though you've not done a full year. I understand that's unlawful.
I'll refer you to Mr. Wesley.
Could I give an update?
Yes, please.
So date rationalisation was a policy change made in 2013 to make the renewal process and the declaration of wages easier for small businesses. So what it means is that the policy is set to the last day of the month. So in the first year of a policy, it may be less than 12 months. The policy is less than 12 months unless the policy is set up on the last day of the year. That is a practice that's been in place, as I say, since 2013 as part of the reduction in red tape. It's part of it's aligned with the market premium practice guidelines, and it's part of the submission on premiums that we make to CIRA each year. So yes, that's a practice that's been in place for a long term. I think where you're getting to is that there are very unique cases where the way if a small employer moves to the experience rated, they might grow and become an experience rated employer. Their very first year of being of claim, the year of claims experience prior to that, if they make that move a year after incepting a policy, changes the way that first year is treated from a claims perspective. There's about 500 cases each year where a small employer moves into the experience rated category that have done that within the first year of inception. And there's a small number of situations in that circumstance where if an employer had a different experience in the first year, because it's less than a year, we treat all first year claims the same, the claims experience the same across all employers moving into the experience rated category. So there are circumstances where that will impact the claims experience that an employer has. But
are they the ones that you've been refunding?
So what I could find out in the break is that there was one circumstance over the course of time where there was a refund made inadvertently for an adjustment for that, but that is not our practice.
Right.
And I can find one example.
So your position is that this practice of shortening the policy period to align with iCare's billing is permitted?
Yes. I've got...
Is it also your evidence then that CIRA has not raised an issue with this in the past?
Yes, I have got no... in the time since you asked the question, there's no issues that we can find that have been raised by CIRA. And as I say, this practice is part of our premium filing each year.
And can you tell me where exactly in the MPPG it says that this is permitted?
I'll have to find that, Ms. Boyd, but it's part of our premium filing to CIRA, which we make every year.
And can you also tell me how it interacts with Section 155A, that particular section of MPPG?
So what I'm advised is that Section 155A says a policy of insurance issued after the commencement must be issued for a period of 12 months unless the authority otherwise approves in a particular case or class of cases. Section 168 allows for the making of guidelines by the authority. We rely upon those guidelines in making our annual premium filings to CIRA. We include the need for date rationalisations in the timings, and CIRA, in not rejecting the filing, CIRA essentially accepts date rationalisation practice, which, as I say, has been in place since 2013.
So, okay, because CIRA initially found that it had no legal basis, but I understand it's later reversed its position. So, I will have to maybe take that up with Sarah as well, but I will come back to you in the afternoon with some more on that. But Minister, this particular issue I've just been discussing, has that been raised with you previously?
So I've just sought advice from my office that. So I understand that there has been a representation that's come through our office just recently. So I'll get that info for you, and I'll be seeking further advice.
Okay, great. Thank you. Let me just check if I've got anything further. One second. I just wanted to talk to you, Minister, about this issue around surveillance on of people sort of as part of investigations when they're first making a workers' comp claim. Now, we've heard a lot of evidence in previous inquiries around the sort of psychological harm that surveillance can cause, particularly for someone with a psychosocial injury.
Yeah.
Would it concern you to hear if a New South Wales government agency would have a policy requiring the use of investigators for all psychological injury claims, or any broad rule that mandated surveillance of a certain type?
So you're saying that government agencies use surveillance?
So government agencies routinely use surveillance when people are coming forward with workers' comp claims, and when you look at the data,
agency or the
agency,
so the agency, the insurer.
So the agency has an understanding with the insurer, and it's the agency that is the one that sets the policy for the insurers to follow, is my understanding. So if you look at something like New South Wales Health, the degree of surveillance that they do of workers coming forward with psychosocial injury is far higher than, for example, Department of Education, and that's based on a sort of an overall policy setting from the agency to their particular insurer.
Yeah. Look, I'll take advice from Mr. Wessling on that, but I just want to make it very clear that I have had meetings with injured workers who have had a level of surveillance that has that's concerning, and I understand that there will be times where there is a necessity with respect to particular matters in terms of seeking advice or seeking evidence and information within the bounds of the law, but with respect to some of the matters that I've heard in private, I've raised those with iCare. I do have concerns about the use in general. However, I understand its necessity for all sides. So for underinsurance purposes, for employers, so I understand. So, but yeah, so I'll refer to Mr. Wessling.
Yeah, if I could add, the decision about whether to conduct surveillance or investigation sits solely with the case manager and therefore the insurer, so our claim service providers on behalf of iCare. So I think you're alluding to an allegation that there was a policy that required mandated surveillance.
Well, I mean, so for instance, let's just take a step back. So there's a requirement for iCare to sign off on the use of surveillance, is my understanding. Is that your understanding?
All covert surveillance comes to iCare,
Right.
yes.
So if we then look at, for example, 60% of health psychosocial claims being subject to an investigation, what percentage of them are coming to you for sign-off?
So to be clear, an investigation, our case managers will conduct an investigation where there's conflicting evidence between an employer and an injured worker. An investigation, though, is not the same as surveillance.
No.
An investigation could just be further inquiries being made from time to time. Surveillance is necessary and required, and iCare does provide, or it requires us to approve that.
So how do you define surveillance then?
I will come back to you with the definition, but our definition of surveillance is optical surveillance. So this is optically surveilling someone.
So what we're told by the injured workers that come to my office is that they're being subjected to social media surveillance, for instance, and really shocking cases of like even a person's family having their social media surveilled to work out if their parent is, fit enough. It's quite extreme and quite damaging. You wouldn't view that then as surveillance for iCare's purposes?
So we don't approve desktop investigations that look at public social media sites. No, but you're correct though. That does occur as part of investigations.
Yeah.
They're governed by a broader standard of practice set by CIRA around how and when they need to be conducted. And we are at the moment looking at our processes and procedures around specifically desktop surveillance in relation to social media.
So my understanding is that it's not actually legal to pass the investigation reports for that sort of thing across to the IME for the purposes of a dispute. So what's the point of that level of investigation?
Well, as I said earlier, the case manager making a decision on a claim will often get conflicting pieces of information from an employer and an injured worker to help make a decision around a claim, and will commence investigations. It's a normal part of a claim, particularly in psychological claims, workplace type claims where there is often conflict in the evidence being provided.
Yeah. I think, we can agree that factual investigations are an important part of workers' compensation, but they need to be used judiciously, otherwise you can really erode the trust of workers in the system. When you're looking at, for example, 60% of those health psychosocial claims being subject to an investigation versus other departments not doing that, so are you saying that can only occur because their health has contested that number?
I don't know the exact stats you're referencing, Ms. Boyd, but I can take that and take that on notice and look at that. But again, investigations is a broad term that incorporates many different activities on a claim.
Minister, do you think that there should be tighter regulation around the use of this sort of desktop surveillance? And it's kind of an old-fashioned idea that iCare have around what surveillance is.
Yeah, and having spoken to probably the same injured workers that you have and we all have, I think that this is something that definitely, let me make this clear, families and children should be off limits. Simple as that. So it's simple as that. And if you're going to conduct an investigation, doing a social media search or desktop, I'm not an expert, I'm not a claims assessor, but I think just doing common sense. Common sense, but also is it within the bounds of the law? And with respect to surveillance, we have to be very mindful. What Mr. Wesling indicated, that yes, there'll be a conflict between reports, etc. There is a whole claims process. It puts people through a very difficult situation, as we know, with what we're trying to do in terms of workers' comp reform. But in terms of this type of surveillance, I'm very concerned. Families and children off limits. It's something I'll review and I'll take back and report to you, to the Parliament.
Thank you.
But yeah, I do have concerns.
And given that we know that the quicker claims are, accepted and processed, particularly for psychological injury, the quicker someone returns to work statistically. Does it concern you that there are certain departments that are effectively sort of applying more scrutiny and holding out on claims than others?
Look, this is something that we're currently working through, as you know, and you've been very actively involved in the workers' comp reform and the bill, and have been asking many questions about this. The insurers have a process with respect to the work that we're doing. Is we're trying to triage, and particularly people who are putting forward a psychosocial claim, is to get in there and triage and try and work through and support those workers. That we're doing that at the moment. You know, Miss Boyd, that for a person, when a person puts in a psychosocial claim, it takes about 8 to 9 weeks for them to see a psychologist. We all know through peer review and through research that is a very long time for somebody to be allowed to languish in a system that is really not good for them. We want to support them right at the beginning of their claim process, support them in every way, and that's why we're investing additional funds, and iCare will have a wraparound process in terms of triaging these workers, and we have to do a better job at returning workers back to work. Thank you.
Thank you, Minister. The opposition, Mr.
Minister.
Tudorhope.
I'll ask this. The HSU health workers were offered 4% additional pay. You're still only offering the nurses 3%. What part of the new fair pay policy justified the extra 1%?
With respect to, Mr. Tudorhope, with respect to the HSU, that the HSU members have accepted the government's offer to increase wages, which will deliver benefit to more than 50,000 health workers, including hospital cleaners, security specialists, scientists, dentists. Scientists. Now, this is the prime example of how the government's wages policy work. The union and the employer negotiating an outcome of mutual benefit, and I'll explain and I'll give you the details of the agreement. So the agreement's 8.5 over 2 years, so it's comprising 4% plus 0.5 in super, backdated 1 July 2025.
This is a press release, is it? You're reading?
No, but I'm giving you the...
Right,
I'll give you the example.
What part of the fair pay policy is the difference between what you're offering to the HSU and
I'm
the
coming to it now.
Okay.
But you can't... you're comparing two different sectors. You're comparing two different... The nurses and midwives about to start an arbitration on the 30th of September.
You offer the HSU 4%. Why don't you offer the nurses and midwives 4%?
I'm getting to... Because every union and through its membership will examine... have examined the government's offer that we made in May 2024.
Why did you offer the HSU 4% and the nurses 3%?
No. Because there was a bargaining process, and that will continue with respect to modernising their awards and their classifications. I'm happy to outline the mutual gain for both the government, the people of New South Wales, and the workers. So I'm happy to outline that, how we came to that 4%. There was a bargaining process, Mr. Tudorhope. This is our new system.
Thank you, Minister. It's now time for a question or two from Ms. Boyd.
Thank you. Just back on that surveillance point, we got questions, answers to questions on notice from our inquiry into the Workers' Compensation Bill in June that says, from EML, from the 31st of August 2017, the surveillance and desktop investigation guidelines for iCare agents decreed that iCare and iCare agents must make an application to iCare, and approval is at the discretion of iCare, including the duration, scope, method of surveillance, and the proposed investigator. So does that mean that you're not asked to actually approve desktop and social media surveillance?
The part that we don't approve is desktop social media investigation surveillance. That's right.
Okay. Can you provide us with a copy of the surveillance and desktop investigation guidelines for
Yes.
ICARE agents? EML also said in that answer, quote, ICARE has advised EML that it has responded to the committee on this question at a scheme level, end quote. But ICARE never did. Are you able to provide us that?
So on what topic? On
the use of surveillance.
Okay, I'll take that on notice, Ms. Boyd.
Thank you.
Sorry.
All right. That's all. Thank you, Chair.
Thank you, Ms. Boyd. Opposition, you have one more?
Thank you. Minister, if I could just ask you in relation to the McDougall review. Sorry, I just have to find the right piece of paper. I have too many here. What has changed in triage and the investigation decision-making panel since the McDougall review?
So when you say the McDougall, I'm not trying to be difficult or anything.
No.
So with respect to the IDMP,
Mm-hmm.
there were recommendations 6, 7 and 8.
Mm-hmm. And I suppose what I'm asking
And-
is what's the
and-
practical outcome of those
Yeah,
recommendations
point of order's
been?
been taken.
Sorry.
I know. Yeah. Thank you. I very much appreciate the energy there, Mrs. Carter, but we've run out of time, and we're now into the time allocated for government questions. And in the absence of government questions, that means we have now concluded the morning session. Thank you very much, Minister, for attending. We are finished with your questioning, and everyone else. We will be back at 2 p.m. to continue the hearing with questions to our officials. Thank you very much, everyone.
Thank you.
Thank you, Chair.
I will
Yeah, yeah.
We're live. We're good. We are back. We're live. Hansard is ready to go. Welcome back, everyone. I hope everyone's refreshed, reinvigorated. We will now turn to questions from the opposition. Mr. Tudor.
Mr. Carter, in fact.
Oh, I'm sorry, Mr. Carter.
No
Sorry.
worries. No.
Apologies.
No, not at all. Ms. Shaw, I think these questions are probably for you or perhaps for Dr. Casey. Since March 2025, has the psychosocial complaints form that SafeWork New South Wales used been adjusted on the question of whether the matter relates to race discrimination or not?
Well, thank you for the question. Dr. Casey might provide some context, but no, I'm not aware that the form has been changed at all.
Could you take that on notice just to check that
Confirm?
it hasn't
Yes,
been
absolutely.
changed? Thank you. And are you aware of any proposals for that change to be made?
No.
Okay. Any change to the triage process?
So we have made changes to the triage process, as you asked earlier,
Yes.
in follow-up to the McDougall review.
Mhm.
The triage process was changed from the 1st of July this year, primarily to enable us to triage where we want to have an inspector response and to better utilise some of our other regulatory responses that we have. For example, to make inquiries with a PCBU where you don't necessarily need an inspector to go out. So it better utilises our inspector foot power, if you like, to be able to prioritise. As you know, we have a number of categories of response where we need inspector effort for responses in those first 3 categories. And so it enables us to better utilise inspector time and as we want to be seen and felt as much as we can with our soon-to-be 469 inspectors out in workplaces.
Great. Can you help me with the process once an inspector practice note request has been approved? Are there further steps for the implementation of that, or is that the end of the chain?
I might ask Dr.
Yes,
Casey to
of course.
respond to that.
Yeah, look, thank you, Commissioner. Yes, there are. So we have an inspector practice panel, so a group of inspectors and other people within SafeWork who come together, and indeed if a practice needs to change, they agree on that practice, and then our training and development team incorporate that into the training of both existing inspectors as well as making sure that it's part of our new training inspector program.
Would you be able, on notice, to provide the committee with documents in relation to an inspector's practice note that was approved on the 27th of March 2025 that approved psychosocial complaints form and triaging process to be adjusted in relation to race discrimination, and what further decisions may have been made in relation to that?
Absolutely.
Thank you very much. If we could turn to the McDougall report, I don't know whether you're able to assist, Ms. Shora. Of the 46 recommendations from the report, are you able to identify the government's priorities for this year?
So, yeah, thank you for the question. We have we've completed about half of the McDougall recommendations so far. We expect the remaining half to be completed by the end of the year. And I think to your earlier question, a large number of those go to the training and support for our inspectorate, and as we expand the inspector workforce. And part of the reason that we're tackling that in the second half of the year is because in becoming a standalone agency, we've had to stand up our people and culture and our internal training resource as well. So we need that in-house before we can actually then enhance the training program. So we're well on track to have the body of those McDougall recommendations completed by the end of this calendar year.
Okay, great. And the follow-up review of SafeWorks complaints and grievance handling procedures that was called for within 9 to 12 months, has that occurred?
That's underway at the moment. It will be completed by the end of the year.
When do you anticipate that it will be completed?
We'll complete that by the end of this calendar year as well.
And will the results of that be made public?
As much as we can, absolutely.
Great.
Yes.
Thank you very much. What changes, if any, are currently being considered to strengthen psychological safety and the management of traumatic workplace incidents?
In general terms, around our psychosocial...
Yes.
Look, I might get Dr. Casey to start. One of her responsibilities is our staff inspector training. So
Thank you.
We'll get Dr.
Thanks,
Cotsis.
Commissioner. Yeah, so look, in its broadest sense, we talked a little bit about in the previous session around some of the training and supports, both internally across our inspectorate, so ensuring we've got vicarious trauma, we've got trauma support for those as they're carrying out those duties, and then that extends in terms of our regulatory footprint through our psychosocial strategy, which is a current strategy. We've got a Respect at Work strategy, and then we've got psychosocial, which is also an annual regulatory priority. So in all those areas, strengthening both our compliance approach as well as making sure that we've got the right tools, checklists and other things to support PCBUs. In our recent compliance activity that we undertook across July to coincide with us becoming a standalone, a key output of that activity was a psychosocial activity across PCBUs in relation to, I guess, enhancing awareness around their duties, their responsibilities in the psychosocial space. So the breadth and extent of our regulatory approach is from education, awareness, right through to compliance, and then a real focus internally, making sure we're well equipped. We talked earlier today in relation to the psychosocial uplift program, so a significant focus for us over the next period will be ensuring that we've got I guess we're attracting a diverse cohort of people into Safe Work. So we want to make sure that we've got diversity of inspectors because it's a complex task, and then really focusing in, as the Commissioner said, on our training and our capability.
And specific training around handling traumatic incidents?
Absolutely. Yes. And that currently exists, so it's not to say that it doesn't, but we certainly want to amplify that, and particularly as we bring new people into the workforce and a broader diversity of inspectors, for example, making sure that we have that training that's fit for purpose.
In relation to your inspectors and understanding that the risk of violence, aggression, intimidation against Safe Work inspectors could be high, when one of your inspectors or other workers wishes to lodge a complaint internally against Safe Work New South Wales for an unsafe workplace or, for example, PPE or adequate training that hasn't been provided, who does Safe Work New South Wales send the complaint to?
So currently, we're working through, so from 1 July, we've separated from the Department of Customer Service, and the reason I make that distinction is that some of our complaints handling is still handled by the Department of Customer Service, particularly to ensure that we don't have conflicts of interest.
So who now do those complaints go to?
So now they would go through to our internal people and culture team. But if there's
sorry, why isn't that a conflict if it's going to your internal team?
I might just expand on that if I
sure.
may, Ms. Carter. In relation to if somebody wants to report something from a work health and safety perspective, so it's a hazard, we would want our workers to follow normal workplace health and safety reporting systems. So they would lodge a hazard in the My Safety system, which would then go through to the People and Culture team, and the system responds to it. If, however, they want to report something on an anonymous basis, or they feel that there might be, reprisal or something else, that then goes through to the professional conducts team within the Department of Customer Service. And then if we want to take that further, we've got a reciprocal agreement with the resources regulator, because obviously we can't regulate ourselves. So the Department of Customer Service and Safe Work have a memorandum of understanding where people can access the resource regulator who carry out that function.
And that's a memorandum of understanding. Is that available to and publicised to the entire workforce?
Look, it is. I'd have to check exactly where. We're currently in the process of revising that memorandum of understanding, and that also is because we're now that standalone agency, looking at all those sorts of procedures, making sure that we've got them in order. So we're currently having discussions with the resources regulator about revising those.
Sorry, I don't understand how discussions about a renewed memorandum impact on the awareness and the education of staff that is where they are able to make complaints?
They absolutely, it is advertised.
Right.
All our staff are hopefully aware of those. Sorry, I was speaking specifically around the Memorandum of Understanding. It's not a secret document, but I just don't know where exactly it's publicised. We have a protocol that underpins how that works, and that is absolutely available to all staff.
Okay. How many internal complaints have gone to the resources regulator and have been accepted or investigated?
I'd have to check the exact number, but over, I think about the past 10 years, we've had about 40, which is across Safe Work and DCS, and obviously I don't want
If
to
you could take that on
speak for
notice.
DCS. I can say that currently we have no active matters with the resources regulator.
If you could take
I
that
will.
on notice, that would be great. What happens to complaints that are rejected by the resources regulator? How are they dealt with?
So they're dealt with the same way that Safe Work would deal with a matter if it decided not to investigate or not to proceed with a matter. It's referred back to the requester. The onus is back on the PCBU, which is in this case Safe Work or DCS, to follow up and action whatever is the subject of the complaint.
So the resources regulator has capacity to independently examine these complaints, or they're referred on to somewhere else?
They currently have capacity themselves.
Okay, because I've been given information that they're often referred back to Safe Work New South Wales.
I'd have to take that on notice in relation to
Could
what
you?
exactly that might mean, but certainly in terms of the process, they may be referred back depending on whether they have chosen to action the matter, but it would be for the PCBU then to follow up, not for the regulator to follow up.
If you could take that
I
on
will.
notice, that'd be great. Thank you. And what support is provided to inspectors who have suffered serious mental health injuries in the line of duty?
So we have a couple of, support structures in place. We now have our in-house people and culture team. We've also got a new wellbeing and safety manager. We're recruiting a psychologist, an organisational psychologist to be on staff. But the main way that they're supported, we have a contract with an organisation called Think Ahead, which is a psychology-based service for any inspector that has had exposure to an incident of a traumatic nature, which of course in the line of duty that they do is quite a few. It's mandatory for them to have a follow-up with the psychologist, and then we make the psychologist generally available not just for our inspectorate staff, but also, for example, people who are taking phone calls and other things that may be of a traumatic nature.
And the body-worn video cameras, how much has been spent on the implementation of that program?
I've just got, if you just bear with me, I just did get that in the break. It's here.
So the upfront contract cost for the body-worn cameras was just over 1.1 million, and that was a 3-year contract, which was extended for a further 2 years until the 30th of June 2027.
And what was the cost of the contract extension?
417,000.
And did that include software, batteries?
Yeah, that includes the hardware and a management service.
And so what was the cost of any necessary software?
I'm happy to take that on notice, but I'm assuming
Thank
that
you.
was built into that overall
And
cost.
Batteries and sort of other...
Upgrading things, yes.
Yeah, no, thank you. Is it correct that the large majority of body-worn cameras purchased in 2022 were left in cupboards and not maintained, and when the program was recommenced, Safe Work New South Wales was required to purchase new batteries and have the cameras shipped to the provider for the new batteries to be fitted?
I don't know the history of the body-worn cameras, to be honest. I'm happy to provide some
Can you take that on notice?
Yes.
That would be great. And when you're doing that, can you also have a look at how much that costs the taxpayer for that to occur? Did the 1st of July deadline create any sort of sourcing problems or any rush to get all the body-worn cameras in place?
Dr. Casey?
Not that I'm aware of, nothing specific from the 1 July date.
Okay. What was the time period between body-worn video cameras being issued to SafeWork New South Wales inspectors and the Surveillance Act legislation being implemented to enable operational use by SafeWork New South Wales inspectors?
I might take that on notice. I know that there was a period of time. The regulation changed, I think, in the 29th of May.
Yep.
And as the Commissioner has said, the contract was in place on an upfront basis.
Okay. During the period between when the body-worn video cameras were initially issued to the re-rollout, how many SafeWork New South Wales inspectors were exposed to violence, intimidation and aggression, which the body-worn video cameras could have potentially prevented the occurrence of?
I'd have to take that on notice.
Okay, if you could, that'd be great. Are there costs accrued for workers' compensation or investigations or legal due to no body-worn video cameras being able to be used during this time?
Also, I'd have to take that on notice.
Okay, if you could. Just a question about exposure to hazardous substances and regulatory priorities. Can you tell us how many improvement notices regarding environmental tobacco smoke have been withdrawn by SafeWork New South Wales?
Improvement notices have been withdrawn. So the majority of what we've received, so about 22. I don't think I have with me how many have been withdrawn, if I can take that on notice for you.
If you could take that on notice. And the inspector practice note relating to environmental tobacco smoke, what's the status of that?
We're doing a review of our position on environmental tobacco smoke currently, so I anticipate that will be updated again before the end of the calendar year.
So the practice note is currently in place, or has that been withdrawn as well?
As far as I'm aware, it's currently in place. We might confirm that on notice,
Could
but
you?
certainly we're in the process of reviewing it.
Okay. So you said that you're updating it. What's the driver for updating and what's currently being done in relation to environmental tobacco smoke?
So part of the reason for updating it is to better articulate what our role is, what is the role of health in relation to its obligations and to liquor and gaming, so that we're very clear for our inspectors what constitutes a work health and safety risk for workers in those particular environments, and what a proportionate response is from our regulatory position.
So if you're in the middle of updating, what currently happens if there's a request for service in relation to environmental tobacco smoke?
So we would absolutely take that request for service and prioritise it as appropriate, but it's certainly an environment where there would be a conversation, as happens a lot in our work, with another regulator or another body that has an involvement. So there would be to demarcate what is our particular role and what is our response, along with if health has been involved or with liquor and gaming.
Sorry, it's just not very clear to me, because when you say prioritise as appropriate and there's a demarcation line between health, so if a worker rings up today and says, I'm exposed to environmental tobacco smoke, what happens today?
So we would triage that as we would any other request for service and prioritise it against our framework.
And what would the framework tell you? What would the result of that triage process be in relation to environmental tobacco smoke?
So if that was a request for service, and Dr. Casey can jump in if there's anything I'm not articulating, but we would triage that as a request for service, and whether it needed an inspector response or whether it was we used other regulatory approach, which would be contacting the PCBU, asking for more information, scheduling a site visit down the track. But we would make inquiries as to whether other regulators had active efforts with that particular PCBU.
And if another regulator had active efforts, what would that mean for a safe work?
Well, that might be an effort in gathering more intelligence that they were able to share with us, but it wouldn't mean we didn't respond if there was a genuine, if there was a need for us around work health and safety. We would still execute our regulatory responsibilities.
Because I'm receiving information that no action has been taken in relation to requests for service for environmental tobacco smoke.
Well, I can't comment on that, but I guess what I would say is the tens of thousands of requests for service that we get each year, there is a triage process that prioritises what is an inspector response and what might utilise other regulatory responses.
Perhaps you could take on notice how many requests for service in relation to environmental tobacco smoke you've responded to in the calendar year.
Yes, we can take that on notice.
Okay. I have a question in relation to back pay due to misinterpretation of the award provisions, specifically allowances including single-day meal claims, laundry allowance, and how much Safe Work New South Wales has had to provide in relation to misinterpretation of the award. And given that Safe Work New South Wales has been found to be lacking in the application and provision of worker entitlements to their own employees, why is it that we should be confident that you're able to protect other employees?
Dr. Casey might be able to talk to the retrospective issue, but I'm certainly aware of this issue for our workforce, and it is something that we're actively looking to clarify and address. Obviously, our workforce are out in the field a lot and require the financial support to do their job to the best of their ability, but Dr. Casey might be able to talk to some of the retrospective issues.
Yeah, I think, Ms. Carter, there's probably a couple of things there. There's been a significant piece of work, and I think I would just say at the outset that as of 1 July, we are a standalone agency. We still adopt the DCS policies, and prior to 1 July, we were part of DCS. There has been a significant piece of work around laundry allowances. I'm not sure if that's particularly what you're referring to.
It's one of the things.
My understanding that any entitlement, there was a entitlement from an ongoing perspective, and then there was also a retrospective component that went back for a statutory period of 6 years. That there's been a process that we've worked through with all the inspectors, and those entitlements have now been paid. And obviously, so that was a period that we've worked through, and that just finalised May-June time, so that's quite current. There is also some concerns that have been brought to our attention very recently around some concerns around how, I think it's Section 26, Section 29, around some of the allowances. We're currently working through that. We've had recent conversations with the PSA and others around having a look at that. So that's a very current discussion at the moment.
Okay, thank you. My time's expired, but perhaps we'll come back to that later. Thank you.
Thank you. Ms. Boyd.
Thank you, Chair. Just a quick one to start with. Mr. Wesling, the 2024-25 financial year spend on consultants. What's that looking like?
If you give me a moment. Just 1 sec. I'm just.
You're okay. Is it easier if I ask a question of someone else while you're looking and come back to you in a minute?
I've just found it.
You got it?
So these are unaudited.
Yes.
Unaudited numbers, 3.423 million. So 3,423,000 is the spend on consultants this year. Oh, sorry, that
so
is
it's
non-actuarial, and then actuarial is 5.374 million of actuarial consulting. So those are our two consultant rows.
All right, that's a lot less than previously.
That is less than prior years. Yeah.
Good. That's what we like to see. Thank you. I might go to you, Ms. Scora. I understand there's a thing called Trolex, which is like a dust monitor technology, and that the New South Wales Chief Scientist was providing advice on its efficacy. Has Safe Work New South Wales got that advice back?
No, we haven't yet.
When was it referred?
I think it was referred at the beginning of last year.
Okay. When are we expecting the report to be available?
I expect it's in the next couple of months.
Okay.
Yeah.
Do you know how many Trolex devices are currently being used by businesses in New South Wales?
No, I don't know that.
Okay. Do you have any, I guess, oversight of how many workers are potentially utilising it and maybe thinking that they're relying on it?
I don't know how many. I know that workers in those where they have that sort of exposure, there are a number of techniques that companies use. I couldn't tell you how many are using that particular device.
Okay, thank you. Prior to the restructure that was implemented in November last year, was there a specialist directorate of health and safe design?
Dr. Casey?
Yes, there was.
There was. What was their function?
I'm afraid, Ms. Boyd, it was before my time joining SafeWork as well, but it was, as you said, a specialist directorate, so it had the psychosocial, a focus on good work design. It was a specialist directorate focused on that.
Okay.
It also had some return to work functions as well, sorry.
Okay. Do you recall what some of the specialist teams were within?
I'd have to take that on notice. I joined SafeWork sort of at the output of the new operating model, which commenced in November last year, which already that directorate, I guess, no longer existed through the reorganisation of SafeWork through that period.
So that directorate was disbanded. Where did the specialist inspectors go from that?
So we currently have a directorate that has all the psychosocial specialists, the return to work specialists, and a really important focus around capability and engagement. Our Respect at Work task force is also in that specialist directorate. So while that directorate that you've talked about no longer exists, it's not to say that any of the functions that were sitting in that directorate are not housed somewhere else within SafeWork. So SafeWork was reorganised around efficiency, looking at good design, good organisational design, and really importantly, within the funding envelope at the time, it created an extra 40, I think it was 40-something inspectors. So it was really important that we, reduce some of the enabling functions, if you like, so that we could have some more inspectors. So it's not to say none of the functions were not carried over into the new
So I understand.
structure.
So on that, then I understand that there was a team that was doing ergonomics and work environment stuff or working environment. Where did they go, and do we still currently have
Yes,
some
we do.
specialists in that
We do. We
area?
do. When they sit in another directorate, and you're going to test my naming convention here, but absolutely. So we do have ergonomists on staff. We've got hygienists. So there's SafeWork is now structured on. We've got an operational footprint. We've got a specialist footprint where all those specialist functions are spread across 4 directorates. So those functions still exist within SafeWork.
Are they called ergonomists?
Ergonomists.
I don't know. I've never heard that word before. That's quite funny.
You're absolutely right.
Yeah, it's quite fun to say. Thank you. So how many of those ergonomists are there?
I'd have to take the number on notice, if that's okay. Yeah.
I understand that the workers' compensation sort of bill is growing for those manual handling injuries. It's gone from 2 billion in 21-22 to around 2.6 billion in 23-24. So I'm quite keen to sort of see what's happening in terms of specialist inspectors in that area.
And look, SafeWork absolutely has a focus on musculoskeletal disorders generally, and has a strategy. While that bill, as you said, is growing, I think musculoskeletal disorders are, typically anywhere between 40 and 47% of injuries in the workers' compensation scheme. So SafeWork continues to have that as a focus. Both in a specialist sense, but also in our general inspectorate as well.
And is there any sort of plans on foot to, increase the overall size or allocation of that team, or is that subject to the review?
Not at this stage, but yes, the review might highlight that that's a need we have, absolutely.
Okay. All right, thank you. Tell you something quite different. And I'm not sure whether you can actually, whether this is a question for Treasury or not, but Just looking at the with the workers' compensation amendment bill that was put forward, there is this change around the reasonable and necessary test for medical claims. I was wondering if any work was done on identifying the AMA payment codes for sort of which medical procedures would likely to sort of fail the new test.
I'm not aware of any of that work, Ms Boyd, unless my iCare colleagues are.
Ms Boyd, we'll take that on notice. I think we have done some work on that, but we'll take it on notice.
Thank you. That would be very handy. Okay, I will come back to that. I think that might be it for now, but please come back to me in the next round if that's okay.
Certainly.
Thank you.
The opposition. Mrs. Carter.
Thank you. Perhaps if we can keep going. I believe we're talking about clause 26 of the award. Has there been a calculation done of how much back pay needs to be paid to workers within safe work to meet the requirements of clause 26?
Not to my knowledge, Ms. Carter.
Okay.
As I said, we're currently looking at that. No.
Okay. And I understand that other government agencies don't require provision of receipts. The allowance is triggered by the worker being required to travel, but you have different requirements to, for that provision?
I'd have to check whether we've got different provisions.
Okay.
As I said, we've got a policy that we follow. I haven't compared it to other agencies.
Right. If you could take all that on notice, I'd be very interested.
I guess what we're following is the DCS policy. So
Mm-hmm.
that's one of the areas where we've continued. So payment of travel of travel costs on a actual basis. And I think the question inspectors have is to be paid an allowance rather than actuals. And I think that's what we're trying to get a position on.
I think the issue is we want to make sure that everybody is paid fairly and
Yes.
that everybody approaching safe work has confidence that safe work can not only regulate their workplaces, but they internally are well regulated as well.
Correct.
Yeah,
Yes,
thank you.
that's fine.
I understand that you've recently, in fact, I think you told us you've recently increased to 449 inspectors. Is that right? Did I remember that figure correctly?
Once we've finished the current recruitment from the from the 1st of July investment, it'll be 469 inspectors, but we're
Thank you.
in the midst of recruiting.
Thank you. And I understand that as part of this restructure and recruitment, there are additional supervisory positions known as team coordinators. Is that right?
That's correct.
And that they are authorised inspectors.
That's correct, yes.
So how many team coordinators are actively involved in what we might call inspector work?
I'd have to give you some advice on that, but I think, as I said before, there is a part of our structure is that certain matters or certain types of work would go to different levels of seniority of inspector, whether that's a state inspector or a team coordinator, and so that's where you'd see that sort of matter come forward for those roles.
So are team coordinators administrative or inspectorial in their role?
Do you want to?
They're under the inspector ward.
No. It's
Sorry.
not. What's the work they're doing on any given day?
So
Would their work look more like administrative, or are they out in the field actually visiting sites and fulfilling service requests?
it could be a bit of both.
Okay,
as
so
the Commission
the
said.
typical team coordinator, 20% admin, 40%, 60%, 80%.
I couldn't tell you the typical day off the top of my head.
Okay, but surely you must have some idea of what the role of a team coordinator is, how much admin would be there?
They would take on a level of admin, obviously. I mean, it might be sort of 50-50, but, you know, it's not going to be a formula.
What would the job requirements, what would the expectations of them be? How much admin, how much out in the field?
Time. I'd have to provide that information for you on notice.
Yeah, if you could. And I suppose the other thing that would be very interesting to have is what percentage of their jobs are they actually fulfilling the tasks of an inspector? And if we are counting them as inspectors, are we actually overstating the workforce of inspectors that Safe Work New South Wales has at their disposal? Okay, thank you. I understand that managers within Safe Work, that you have a system of on-call managers, on-call after hour, to receive calls, and those managers quite understandably receive overtime for that night work. Is it true then that those managers are often fatigued due to the number of calls overnight that they've taken, and they then take a day of leave to recover and report back on call the following night?
I am not aware of that situation, Dr. Casey.
That's information I've received.
Yeah, look, I'm not specifically aware of that, but I am aware that we have recently looked at that from a workload, from a work design perspective, in relation to concerns that, the work could be designed in a better way. So that's an activity that's just recently been completed.
Are you able to take on notice on how many times over the past 6 months an on-call manager has taken leave the following day?
Yes, we can take that on. Yes.
That would be good. All right. Thank you. My colleague.
Mr. Tudor.
Mr. Wesling, were you responsible for the suggestion of 31% whole of person impairment for limiting claims under the Workers' Compensation Amendment Act?
No, Mr. Tudor.
Were you, Ms. Apple?
No, Mr. Tudor.
Were you, Ms. Campbell?
Treasury provided advice on a range of scenarios, but the decision is a government decision, Mr. Tudorhope.
So who in Treasury landed on the 31% figure?
As I said, Mr. Tudorhope, we modelled a range of scenarios and received data from iCare, and the position put forward in the bill is a position of government.
Well, was there a model produced which identified 31%?
There was
as the model which made the greatest amount of savings for the government?
Well, there was modelling on a range of percentages, Mr. Tudorhope, and as I said, the position on 31% is a position by government.
So the modelling included potentially 25%, did it?
The modelling included a range of percentages, yes.
Did it include 25%?
I can't be specific about that, but we have proactively, as you know, Mr. Tudorhope, released a range of information on the Treasury website which would show you what has been modelled.
There is a concept which floats around, which has some merit, called threshold creep, in relation to one of the concerns that Treasury raised in relation to landing on a particular model. Are you aware of that?
Yes, I am aware of that.
And you're aware of that modelling to potentially limit threshold creep?
The threshold creep is in relation to the classes within the PERS scale, as you would be aware. And so the 30% threshold represents the difference between a Class 3 and a Class 4 impairment rating under the PERS scale, which is used to calculate the WPI. And whilst it's difficult to move from Class 3 to Class 4, so Class 4 is 31 and above, it's much easier to then move within the Class 3, and that is where this concept of erosion within the threshold comes from.
So where is that document to be found in relation to the advice that you are reading from at the moment?
Well, that is a note that's been prepared for the purposes of budget estimates. As to whether it relates to information that is on the Treasury website, I would take that on notice.
Are there any other alternatives for dealing with threshold creep other than landing on the what I would suggest is the crude figure of 31%, which would eliminate threshold creep? Are there any other suggested alternatives to eliminating threshold creep?
I don't have specifics on alternatives, Mr.
Were they
Tudorhope.
ever considered?
I would have to take that on notice.
And again, this is possibly to you, Ms. Campbell, moving on to modelling in relation to presumptive cancers.
Mm-hmm.
If a firefighter contracts mesothelioma, under what conditions does he or she have access to financial and medical support under the Workers' Compensation Dust Diseases Act 1942.
I would need to take that on notice, Mr.
Do you know,
Cheetah.
Mr. Worsley?
I would need to take that on notice to get it.
Anyone else at the table, feel free to contribute. Well, on that basis, have you had an opportunity of reviewing the proposed presumptive cancers legislation which is currently before the Parliament?
I'm aware of the legislation, Mr. Tudor Hope. I have not read it myself.
Has anyone in Treasury read it?
Yes, my team have read that legislation, or the bill, sorry. Yep.
So have they provided advice as to whether if mesothelioma was added to Schedule 4 of the Workers' Compensation Act and firefighters were given access under this provision, would they have better support or access as arising from the inclusion of that condition in Schedule 4?
I'm not aware of the specific advice, but obviously the inclusion of additional cancers into the legislation would thereby entitle claimants to the benefits under that scheme.
And in the modelling you have done on presumptive cancers, and I think we've heard the Minister say that that modelling is available, have you, how was mesothelioma treated for the purposes of that modelling?
I would have to take that on notice,
Thank
Mr.
you.
Tudor Hope.
In terms of the costings that you have done on expanding the list of presumptive cancers in Schedule 4, what is the estimated initial cost and then the estimated annual cost?
I think that would depend on the position taken by government, Mr. Tudor Hope.
Well,
of what is
assuming that the
included.
government supported the modelling must have assumed what the total cost to government would be, or the scheme would be, in the event that the presumptive cancers were included in Schedule 4.
As part of your bill, Mr. Tudor?
Yeah, that's
Yes.
my question. Yeah, I don't think we've done modelling in respect of your bill, Mr. Tudor Hope.
Yes, you have.
That the modelling that was voluntarily released related to previous considerations of government. I'm not aware that it is specific to the nature of your bill.
Well, the document that you are referring to, it appears to deal with each of the cancers that are raised in relation to the bill. Do you say that the modelling would be different now?
I would have to take that on notice as to the specifics of the modelling.
Just ask this: in relation to that modelling, was any consideration given in relation to retrospectivity in relation to the various conditions? Did you apply that as one of the assumptions?
I would have to check that to give you an accurate answer, Mr. Tudor Hope.
Have you had an opportunity of reviewing the Sarko decision, which I referred to this morning?
I am not familiar with that, Mr.
Have you had an
Tudor.
opportunity, Mr. Worsley?
Yes.
In light of that decision, have you provided any advice or costings on introducing provisions to amend Section 140?
We have not.
So, as it currently stands, Mr. Sarko, his remedies or people in his circumstances would remain unable to claim against an uninsured employer.
For a work injury damages claim, that's right.
Yeah. Can I just go now, Ms. Campbell, to the various iterations of the Workers' Compensation Act, the first print, the second print, and the third print.
Yes.
One of the issues relating to the costings of the impact of the scheme is the amendment to Section 11A. In the first iteration of the bill, of course, the reference was to significant contribution, and it is now predominant is the condition. has modelling been done as to the impact of that change?
Let me just check that for you, Mr. Tudor-Hope. The modelling work, as you know, is largely done by iCare and provided to Treasury. I do somewhere
Does Mr. Wesling know?
Have.
I'm trying to get the answer for you, Mr. Tudor.
Are you aware, have you got a note on this, do you, Ms Campbell, that you'd like to?
I recall reading somewhere, Mr. Tudor-Hope, about the modelling differences between the two pieces of legislation, which I'm going to try and find for you.
The current situation, of course, is that under the current provisions, which in fact retains the use of the word predominant, very few actions or defences raised by employers are successful. Is that your understanding?
Could you ask the question again, please?
If the test is predominant relating to the cause of the injury, is it your understanding that very few defences raised by employers are successful?
I don't think I can answer that question. I can answer the question on the modelling and that we have not undertaken modelling on the difference between predominant and significant.
Are you sure about that?
That's the
because
advice. Yep.
The modelling was done in relation to the amendments.
Correct. Yep.
Which was suggested by...
I think it's a highly complex matter that's going to be impacted by judicial interpretation, which makes it quite difficult to model the nuance in the language. Unless
Mr.
my
Wesling,
iCare colleagues...
I'm still trying to find out, Mr. Tudor.
Is it also your understanding, Mr. Wesling, is that employers who seek to rely currently on the provisions of Section 11A, very few defences are successful by employers who rely on that particular provision?
Yes, that is a common issue raised by employers, yes.
Why is that?
Point of order's been taken, Dr. Kane.
I'm not trying to be difficult. I just, this line of questioning generally has sort of veered very much into sort of legal peculiarities and interpretations. I'm not trying to be difficult, Mr. Tudor-Hope. I just think it's...
This is the administrators of ICARE. They administered this out.
I don't have a point about it, Order, because I think that the honourable member has a penchant for legal peculiarities, so, you know, it's one of his favourite topics, so we'll let him go. But as long as the witnesses have the opportunity to answer...
So,
fully.
Can I answer your first question? No specific modelling on the wording change has been done by our actuaries. To answer the second question, the Section 11A reasonable management action defence has been tested since it was introduced numerous times through the PIC. And obviously there's a generally accepted level at which that defence is successful or not successful, and the outcome currently is that Section 11A defence is not reliable in very many circumstances.
So if employers, in terms of wanting to establish a reasonable management action, were seeking to rely on the current Section 11A, that would be, in many respects, in terms of, even in view of the position taken by your service managers, they would be advising their clients that it would be unlikely that their defence would be successful.
That's often the case, yes.
Can I ask you, in relation to the last iteration of the bill and the introduction of the new Schedule 4, which is the schedule relating to the duties of conducting businesses or undertaking involving digital work systems? Ms. Campbell, whose idea was it to introduce this particular provision into this new Act?
The introduction of that provision was a decision taken by the government, Mr. Tudor-Hope.
Was there advice as to the necessity of introducing it into a Workers' Compensation Act?
My colleagues at Safe Work might have some views on this, because this obviously relates to how, safety in the workplace, in a digital workplace, is managed.
I have some sympathy for the issue. I have some sympathy for the issue. I just wondered why it was appropriate to drop it into a Workers' Compensation Act rather than an amendment to the Safe Work Act or some other standalone act. Why was it necessary?
A point of order has been taken. Dr. Kane on a point of order.
I think that Ms Campbell has already rightly identified that that was an issue for the government to decide, and in fact that's for the government to answer, not Ms Campbell.
Yeah, I uphold the point of order.
Can I ask you, Ms Shura, how many of your inspectors have expertise in relation to digital work systems, including coding, algorithms, and the like relating to the digital workspace?
I couldn't tell you how many have that particular expertise, but they would certainly be as part of their regular work, looking at systems of work allocation, which could extend from a piece of paper at sign-in through to a digital system. And if that's relevant to the particular request for service that we're looking at, then they'd want to look at the systems that allocate work. So it's just part of our regular work.
Well, let's just get real on the ground here. You've got a Safe Work officer who attends on premises in circumstances where potentially surveillance equipment is being used, or artificial intelligence is being used by the employer. How is it that you say that the Safe Work inspector will have the relevant expertise to be able to examine the software system potentially, or the digital workspace of the employer for establishing potential breaches of the Work Health and Safety Act?
Well, firstly, it's got to be relevant to the harm that we're particularly there to investigate. And I would say across all of the industries that we regulate, there is changing technology all the time. And so our inspectors, whether that's in construction or in healthcare, our inspectors and how businesses operate, our inspectors are constantly being re-equipped to understand how does a business work? How does this particular industry do its business? And that's an important part of why we have the relationship with individual sectors, why we have that investment, so that we can partly keep our inspectors up to speed with what is going on in technology across industries.
And this includes coding, does it?
Well, it includes systems of business, which I think that goes to.
And there are a multiplicity of software programs which are available. Some of them are potentially purchase off-the-shelf software systems, and some of them are industry-specific. Some concerns relating to this legislation involve potential access to data, privacy concerns. Did you have any consultative role in relation to the addition of this provision?
Well, we provide advice, as agencies do, in our case through the Department of Customer Service, to government on these sorts of matters. So anything that we do has to sit in as part of our regulatory framework and our regulatory practice.
Yeah, well, I understand that, and in fact the regulatory to assess various risks which are spelled out in the relevant provision. But I just wonder what, in terms of the issues which arise in respect of the use of this new opportunity for regulating that, whether you had the level of expertise and whether there was sufficient consultation done in respect of potential privacy issues, IP issues, that material which potentially is a concern to industry.
I can't speak to the consultation and what industry might have raised, but all I can say is from our perspective, business systems of allocating work, anything that might be relevant to the harm that and the risk that we are there to investigate is what we would examine. And it's part of our ongoing work to upskill our inspectorate to understand what systems businesses are using, whether that's in their particular industry or whether it's for the management of their business.
Ms Campbell, are you aware of the consultation which took place in relation to the inclusion of this particular provision in the Amendment Act?
I can't speak for what consultation the government carried out, only that we provide advice as an agency does upon request of our minister.
Are you aware whether
Mr. Tudor, sorry, time's expired.
You're okay.
That was my fault. Apologies. Thank you, Ms Campbell. Ms Boyd.
Thank you. Just going back on a couple of things I was raising earlier. I understand that we just got distributed the answers to questions or supplementary questions from our last workers' comp hearing, and so that question I asked about the reasonable and necessary, so when we're going from this reasonably necessary test to a reasonable and necessary test, going through the particular AMA payment codes, ICARE has now provided information saying notably that one of the treatments that will no longer be included is medicinal cannabis. Is that correct?
Well, I think the interpretation is that we would have the test, medicinal cannabis or the other AMA codes may not always be deemed reasonable and necessary where they were deemed reasonably necessary previously.
And massage therapy, not considered to be reasonable and necessary.
I think our best guess is that a higher threshold test of reasonable and necessary, by looking across to similar treatment in CTP, would impact that AMA code. It doesn't mean there will be no payments against that code.
And cortisone injections as well. I mean, these things seem like fairly standard types of accepted therapies for injury. That's interesting though, that has actually been analysed, and the difference between the reasonably necessary test and the reasonable and necessary test.
We had our medical team have a look at what sorts of AMA codes may be impacted by reasonably necessary as opposed to reasonable and necessary.
Interesting. Back to the 11A defence that Mr. Tudor-Hope was talking about. I'm just having a look at the table that shows us. So I think this was perhaps provided on notice again as part of the data that we received from ICARE. But my understanding is that in relation to psychological claims, the defence, the Section 11A defence was raised in about 13% of them as of last year, and that the success rate of a Section 11A defence is 83.7% as of last year. Is that your understanding, and is it still tracking in that way for 2025?
I would have to look at the data for 2025, but the defence is we only use the defence if we think there's a reasonable chance of being successful.
But that's quite a significant increase then there was only 172 claims based on 11A in 2019, and then in the 5 years since it's gone up to 804 claims. As a percentage, that's gone from 5.7% of all psych claims to 13% of all psych claims. Is there a reason why Section 11A is actually
I'll take on notice a detailed answer, Ms Boyd, but over that time there has been the significant growth of work conflict-based psychological claims, as we've explored previously, but I'll come back to you with an answer on that.
Are you able to tell me what the average premium in the nominal insurer is for 2025 to 26?
The average premium rate is in 25-26 will be 1.99.
And does that include or exclude GST?
I will take that question on notice. I'm not sure.
Do you know what the Victorian premium is and the South Australian premium?
I do, if you just give me a moment.
So what was the New South Wales one?
1.99.
1.99.
Give me one moment. So the 2025 premium rate for New South Wales is 1.99. I've got the 24-25 data. So it will be, I don't have the 25 and 26 for
the
other
other states and territories.
But the average is 1.8 across all of Australia. And what were the states you were particularly interested in?
So Victoria and South Australia.
Victoria was 1.8. South Australia is 1.85.
Okay. And are you aware that they report without GST?
I'll have to check that. Ours excludes GST, though. I've just been confirmed. The comparison I have, I would assume it's excluding GST because it's a comparison across states.
Okay, so you're saying that we don't report our premiums inclusive of GST? That 1.99 is exclusive of GST?
I'm told it excludes GST, yes.
Could you maybe just double check?
I will double check that.
Thank you. Okay, I'm just going to go back, if I can, to, we were talking before about the LPR. So we were talking about how LPR employers only pay a deposit premium upfront rather than a full risk-based premium. And I think you were perhaps, Mr. Wesley, arguing, well, not arguing, but putting forward a different position in relation to that. Can you explain it in as simple terms as possible what it is that happens with an LPR?
I've asked my team to give me the simple explanation, so let me shoot. So for our LPR product, the employer pays a deposit premium and then adjustments in years 2, 3 and 4. The adjustment factors are calibrated by our actuaries to cover the estimated full cost of claims incurred by the employer, including future benefit payments and the equivalent of the investment income, time cost of money, as if the premium had been collected at the beginning of the policy. The final adjustment applies an adjustment factor. A one-off adjustment factor essentially is an estimate of cost of claims post that point. So does that answer your question?
Not really. My understanding is that they only pay really a deposit, and then if there aren't any claims on that they would otherwise be needing to pay in that year, that they don't pay anything more, and they only end up getting, that amount only gets drawn on if there's actually claims.
Yes, that's correct, but keep in mind these are the very largest of organisations. They all have many claims. So, and as I say, I think the important point is the adjustments made at year 2, 3 and 4 essentially cover the same costs that would be incurred had the premium been collected up front.
How many actually pay a deposit and how many are just giving bank guarantees?
I'll have to come back on. I don't understand the question, but I'll investigate with the team and come back to you.
Thank you. I understand some of them don't pay anything to begin with. They just have a bank guarantee.
Okay, I'll take that on. I'd be surprised. I'm not aware of that.
All right, good. Can we talk about the scheme performance measure? Are you able to explain in as plain language as possible how the scheme performance measure is calculated?
Which scheme performance measure?
So I understand that there is a thing called the SPM benchmark.
Okay. Yes, so for our experience-rated products, there's a benchmark essentially that employers' claims experience is assessed against. So if, as we were discussing earlier, in the small employers, there's no impact of the claim on their premium. They pay a pooled rate. It's pooled insurance at an industry level. So for small employers, claims don't impact individually their premium, it impacts the pool. As employers get larger, there's experience factors that are taken into consideration. So in our experience rated employers, essentially there's a scheme performance factor which is used to determine their performance against, in effect.
How does that get calculated, that benchmark? How do you decide what that is? in a
Well, our
particular year?
actuaries will calculate that.
Do you know what they base it on?
I would have to, I could give you a better explanation on notice.
Okay. That benchmark doesn't get published, so employers aren't sort of able to see what they're measured against. Is there a reason why it doesn't get published?
I don't know the answer to the question, Ms. Boyd. I'll take that on notice.
Okay. So my understanding is that an employer can have a stable claims performance but still see their premium rise because the scheme average has deteriorated rather than their particular experience or their particular performance having deteriorated. Is that correct?
So premiums across all products are still estimated on the basis of an expected level of claims performance, which is generally assessed against an industry average. So if the industry is performing poorly, the base of the premium will increase.
Okay. I understand that in like a number of reviews, there's been this recommendation to have greater transparency over exactly how premiums are calculated because it is so complex. And to be honest, trying to work this out from the information we've been given that's public is really difficult. Has there been moves by iCare to try and explain to people why their premium may have gone up in a particular year in this sort of, very clear way where we can understand?
I think we explain to employers through our premium notices the drivers of increases. Many larger employers have a broker, which will also help to explain that. We make premium calculators available online for employers to use to estimate their premium. I understand that we typically haven't published the full detail of the premium model because we do compete against specialised and specialised insurers from a premium perspective. So we don't publish our full premium model.
Interesting. Okay, that's interesting. Some of the arguments that have been put forward for why we, as I see it, seem to be subsidising some of the larger employers is because they might otherwise go off to a specialised insurer or a self-insurer model. How much does that play into the decisions around sort of setting premiums?
Well, we don't. We price on the basis of a technical pricing model, so that doesn't factor into. We don't price to retain business.
In terms of the development of the products, though, like LPR appears to be developed as a product that is very favourable to the large employers versus the small employers. Was that because we were concerned that otherwise they might try and leave the scheme?
The LPR product was launched to meet the needs of larger employers who want to have more, better outcomes if they deliver better safety and better performance. I think one thing, though, to add to that is that, as I said earlier, the premiums are set to achieve that overall, on average, 1.99%. We price to a break-even premium, so that's basically, we look at that for each of our products. So there's not inherent cross-subsidisation towards larger employers.
So, in the context of the narrative around, and it's true, there have been an increase in premiums for a lot of small businesses, and we've talked about that in our other inquiry as well. We've had this 8%, 8%, 8%.
Yeah.
And there's, I don't expect you to comment on this, but there's been this narrative that somehow the costs of the scheme are out of control and everyone's premiums are going to go everyone's freaking out about their premiums going up. But when you look at the LPR premiums, in the 25-26 premium filing, you've actually lowered their premiums. So how can it be that we've got increasing premiums for small business and then we've got people in the LPR product are getting premiums being lowered?
I'll have to check the point on low premium, but each of the products the premiums are set on the basis of the performance of the participants in that in that product.
Right, but if they weren't part of that product, then the risk pool that exists for the small businesses would be bigger, wouldn't it? Because if you had all of the people who are currently on LPR, if they weren't on LPR and
Yes.
they were instead on the same product that the small business was
Yes.
on, then presumably everyone would get the benefit of a reduced premium, or that amount would sort of even out and perhaps help small businesses to not have to pay as much?
Well, at the moment there's, and we've been unwinding this over time, there's more of a cross-subsidy towards, in the benefit of small employers and large employers.
How do you, in what way?
Well, the technical pricing, the performance of small employers is worse than larger employers. There's lower return to work rates. There's generally poorer performance.
Right.
So there's higher claims costs.
So I'm just looking at the data. In 2024, there were 233 of the very largest employers with more than 21 workers' compensation claims each, with reportable wages over $50 million. 83 of them had 11 to 20 claims. These appear to be quite large figures. Perhaps you could provide on notice the modelling that shows that the large providers are somehow subsidising the lower, particularly in the context of those that have moved on to LPR.
I'll take that on notice, yeah.
Thank you. I also understand there's now a new product which is even sweeter for large companies called LPR Plus. What's LPR Plus?
So LPR Plus is a slightly different version of the LPR product for the very largest employers in New South Wales. I think we have less than 20 employers maybe on that product. And yes, it's a variation of LPR targeted to the largest employers with the greatest sophistication. Employers are only they apply to go into that product because obviously these larger products the impact of claims is over a longer period of time. There needs to be some sophistication to enable those to accept those employers onto those products.
So what is LPR Plus though? What's the benefit for those larger employers?
It's got different settings for the way the upfront premium is calculated and the way the time frame and the way claims are treated on the back end.
So are they paying even less into the overall sort of iCare funds that then get used for investment?
Well, again, the calculation of the premium works out to be on the actuarial models to cover the cost of the claims in that pool.
But they're not paying that premium in the same way that a small business is. They're only paying a deposit and then they're keeping the rest for their own investment income.
Maybe I can take the question on notice and show in response how that product works and the cash flows over time.
Thank you. All right, I might just leave it there for now. Thank you.
Well, just
Thank you, Ms.
continuing there, Mr. Wesling, the real reason that small businesses are potentially a greater risk than big business is they have less resources for managing return to work rates.
So they have less resources?
Yeah, to managing return to work.
Well, our experience...
They don't have HR departments.
That's right, they don't have HR departments, injury management teams, return to work coordinators.
Yep, so that's potentially why. So is there a system to put in place which could assist small business in a better manner to be able to deal with those issues which are available to big business, which are not available to small business?
Yes, and that's one of the challenges we have, is getting the right support to small employers to help manage the return to work process. So yeah, that's...
So what does that look like?
Well, we're working
what do those
on,
resources look like?
We're working on different options for how to... Part of it's educating small employers on their obligations and options for finding suitable duties. For example, the claim service providers play an important part in that in terms of working directly with the employer. So there's...
How quick is that, on an average, is that intervention between the claims manager and the business for the purposes of working out that process?
Well, our case managers have to speak to the employer within 3 days of a claim being lodged, and then there's ongoing engagement with an employer through the life of the claim. A a lot of that needs to be around how you work with a small employer. We've tried things like providing very simple information cards on here's what a typical claim looks like, here's the obligations of an employer, here's the sorts of things to consider in terms of providing suitable duties if you're in a very small business. So those are the sorts of things our case managers are working with employers to get a better understanding. Most small employers might have a claim every 10 years or even longer. So small employers aren't skilled up to understand what is a complex system to work through a claim, and that's what we're working with small employers to get better information, better support through the life of a claim. Digital tools is one area we're working on, self-service type tools and provision of information.
To the extent that small business become proactive in adopting safe work systems for their employees, do they get any benefit from doing that?
Small employers today have access to the Safe Employer reward discount. It's a 7.5% discount, which applies to employers who haven't had a claim for 3 years. It's a bit like a no-claim discount. Mm-hmm. So that's really the extent of safety incentives for small employers in today's model. We'd like to look at other incentives.
Like some sort of safe harbour type schemes?
I'm not sure what that...
Well, in other jurisdictions, it is acknowledging the work that people do in their own business to ensure that they're running a safe business.
Yes. Yes, and the outworking of that would be obviously fewer claims, so the more you can link that directly to...
So they might proactively have a system for dealing with psychosocial injuries.
Yes, and there's no link of that to our premium model today.
Why not?
Well, there isn't. I mean, we're intending to look at ways we can more closely link.
But wouldn't that be a way of driving down premiums?
Well, I think we have to keep in mind as well that small businesses will have forever fewer opportunities for suitable duties, for example, very small businesses. So I think there will always be a difference in performance between small employers and larger employers.
Ms. Appleton, I'm going to put some questions to you so that you are given, in fact, an opportunity of answering these questions because they've been raised in this forum, not by me but by others. And I think you should have an opportunity of providing an explanation, and that is in respect of the contract with DXC that was terminated by iCare. Are you aware of the suggestion which has been made that DXC has had their contract terminated?
I am, Mr. Tudor-Hope.
And there is a suggestion that the contract was terminated because, in fact, a client of EML, for whom you were previously employed by, took their business to DXC. You aware of that allegation?
I am aware of that, Mr. Tudor-Hope.
Do you want to respond to that?
Firstly, I think in relation to my conflict, I declared my conflict through recruitment. I also have an active conflict that is being managed in terms of EML that goes for another month or so, and that excluded me from that decision. So I was excluded from that decision which was taken by the board.
So just to explain to me in detail a bit how you manage that conflict.
So the conflict, we have a conflict of interest policy that aligns up with Treasury, and also the guidance that was given by ICAC in terms of that New South Wales guidance. All employees and directors are required to declare that conflict. So through both the recruitment, I was employed obviously by EML, but running part of their business called EML Solutions, which had no accountability for the NI or the TMF contracts. So through recruitment, that was considered Mr. Tudor-Hope, and then when I was put into the role, the chair and I talked about that conflict. It was recorded within Risk Connect. The chair spoke with the board as well as General Counsel, and then I was excluded from all decisions and discussions in relation to anything that could impact EML in terms of increased market share. So therefore the DXC decision was one that I was clearly excluded from.
Can you tell us the reason why that contract was terminated?
I'd have to refer to Mr. Wesling in relation to that question.
Mr. Chair, we undertook a range of discussions with the board on the nominal insurer, how the new panel was operating. It was coming up, this was commenced last year, coming up to the 2-year anniversary of the new panel. We had new providers in place for a year at that stage. A series of discussions with the board led to a decision in June of this year that it was in the long-term best interests of the scheme to have a smaller panel, so the decision was made.
Well,
I think you'd started your question there, so I think you just snuck in.
But potentially there are 4,500 claims which were being handled at that time by DXC, which in fact had to then be redistributed or will have to be redistributed. Is that not the case?
Well, you're correct that DXC has in the order, I think, of 4,300 or 4,400 open claims. DXC was the smallest provider in terms of number of claims. And the other thing I would add is that DXC disengagement is not like an overnight disengagement. So many of those claims will be managed to completion. And yes, there will be claims that will be transitioned to other panel members as we move through the disengagement process with DXC.
Thank you, Mr. Wesley. Ms. Boyd.
Thank you. I'm going to have another go, just trying to do a worked example of what I'm talking about with the difference between a small business premium and a large business. So if I'm a small business and I'm paying, say I've been paying, let's say, $50,000 over, say, 7 years of running my business for my workers' compensation premiums, and then maybe at the end of the 7th year, one of my employees has an injury and they're off work for a week and it costs $5,000. I've still put $50,000 in, and yes, there's been that benefit of $5,000, but iCare has had the $45,000. I don't get that back. Whereas if I'm a large employer, my understanding is that the way that LPR product works is that I'll only ever pay the maximum amount of claims, that claims amount that has been incurred in relation to my employees in that year. So it's not the same in that I'm not contributing then to the risk pool in the same way that the small businesses are.
Yeah, I guess the difference, Ms. Boyd, is the premium amount for a small employer is paid upfront, but in that calculation is a benefit of the investment returns that follow that pool of money.
Mm-hmm.
Whereas for the larger employers, the premium is paid more in stages across those 4 years, across 4-year increments, and that doesn't attract the same extent of benefit on that investment, on the investment return.
But if the industry as a whole has a certain risk weighting, and that goes into a small business within that industry having a certain premium, but then you've got a big business that's in that industry that sits outside of it, it's not contributing to the overall pool of funds that iCare has in order to go out and get investment return on it. So you've got this situation where even though they're part of the same industry, they're not spreading the risk equally, because those large employers are still only ever having to pay what claims have actually been incurred, as opposed to the small business that has paid all of those premiums, but they didn't have any claims, but they still
I think I understand what you're asking. So there's a greater risk and reward on the table for larger employers. Yes. So the better performing larger employers will pay less based on their. But the worst performing larger employers will pay significantly more.
It seems like it's not the same form of insurance product, I guess. It's with a large employer, whereas a small employer, it's a bit like if I pay my contents insurance every year and I don't make a claim, but I've still paid it. That's the cost of insurance, and that's what small businesses are doing. But when it comes to these large businesses, they're being able to run on their own, I guess, the riskiness of their own business. It's almost like they're just putting to one side a certain amount of money should they have a claim, which is not really what insurance is for everybody else.
Well, and it's not exactly like that. This isn't self-insurance, as I said before, but there are, I guess it is a closer resemblance to a more risk-reward premium model for larger employers that seek that.
So has there been any modelling done that would show what, I guess, what the impact on the pool of funds as a whole would be for the normal insurer if that LPR product didn't exist and all of those large companies were required to put in and pay premiums in the same way as a small business?
I would have to I don't recall any modelling being done to that extent. I'll take that on notice. I would say, though, that the risk that would present to the scheme is a large number of high-performing large employers exiting the scheme, which would leave more burden on the rest of the scheme.
Because we would allow them to become a self-insurer? Because they have to get, to be a self-insurer, you have to get CIRA approval.
That's right.
So and CIRA approval can only be given in circumstances where it wouldn't put the rest of the scheme in under, I can't remember what the exact wording is in the Act, but something along the lines of undue performance pressure or something, or,
You're
basically.
right, yes.
Right. So we could stop them leaving.
Well, I guess if the regulation or legislation was changed, yeah.
Or if we decided that it was going to otherwise harm the scheme.
Yes.
Thank you. That's all.
Thank you. So, do you recall the reason why the DXC contract was terminated?
Do I recall the reason?
Yeah, the reason given to DXC.
Well, we advised DXC that in the best interests of the scheme, we're making the decision to terminate their contract.
And the relevant provision you relied on was?
So in our contracts, there's a provision, a termination for convenience provision written into the contract.
Indeed. How often is that sort of provision ever relied upon, the by convenience?
How often? I don't know how often.
Ms Campbell, are you aware?
Oh, that's a very broad question, Mr Tudor Hope.
Sorry?
That's a very broad question. I mean, it's typical for government contracts.
In your experience, is it a provision relied upon by government to terminate contracts by convenience?
I would say it's a provision that governments have in the past relied upon to terminate contracts, but as to the quantum...
How often has been relied upon?
I would never be able to hazard a guess, I don't think, Mr Tudor Hope.
I'd invite you to take it on notice if you would, if you're able to.
I'm not sure that we could quantify that across government. There'd have to be some parameters around the question you're asking.
Would you agree with this proposition that terminating contracts for, quotes, by convenience does prevent some sort of sovereign risk of dealing with government?
I would say that parties enter into contracts in the full knowledge that those clauses are there and can be used by a client.
Yeah, but I'm asking you a bit more specific than that. Is in relation to relying on a by convenience effectively just allows one party to terminate the contract.
But Mr Tudor Hope, that may be the mechanism that was used in this circumstance. It's not necessarily the rationale for the decision that had been taken by iCare in the current circumstances.
Well, then you mean they didn't tell the truth when they used the
No,
word.
I think the question you asked Mr. Wesling was how, and the answer he gave was the mechanism in the contract. But, you know, my understanding, and the Treasury Secretary sits on the iCare board now, as you know, is that the board balanced a decision between having enough providers to create adequate competition and not having too many providers for iCare to be able to drive the improved proper performance, which, you know, we all...
Why was DXC chosen as the...
well, I think
last
as
on,
Mr.
first off,
Wesling said, it was
basically?
the smallest market share amongst the providers in the NI and had not yet commenced in the TMF.
Yeah, well, they were the last on, effectively, were they not?
We looked at a range of factors, Mr. Tudor.
Like what?
Well, we looked at size, scale, opportunities to scale up, performance, all sorts of dimensions.
They are... do they have any specific expertise in your understanding in relation to mental injury support?
Well, DXC, along with the panel of 6 providers on the NI contract, were selected as the best providers at the time. So there was a number of strengths that DXC brought.
Thank you, Mr. Wesling. The time being 3:30, we'll now break for 15 minutes for afternoon refreshments and reconvene at 3:45.
Okay.
Thank you.
All right.
Very good. Well, welcome back, everyone. Thank you for reconvening. We will recommence with some questions from the opposition.
So just
Tudor Hope, fire away.
Just, Mr. Wesling, just going back to the issue in relation to DXC, the 23-24 annual report from iCare, of course, talked about the increased competition in relation to claims managers, and suggested that that was a good thing for the organisation to be able to have more claims managers on. Something happened between 23-24 annual report and now, which suggests that we needed to rationalise that number.
Well, I think we still are of the view competition is a good thing. We've rationalised the number by one provider. That was on the basis of the review of how the scheme more broadly was performing, whether we were achieving the scale required in providers to be successful over the long term,
So the scale for the providers to be successful, that was like a critical mass of claims which a provider needed to handle to make it the employment ratio right for the business model of the actual claims manager. Is that what you're telling me?
And the trade-off of, I mean, the more providers you have, perhaps the more competition there is, but the lesser scale there is in the providers on the panel, also the more complicated it is to manage a large panel like that. So we undertook that, a number of discussions with the board, given the performance of the scheme, and made the determination that in the long term.
I think I asked you this, just remember the answer. Why did you select DXC as the one, or why did the recommendation to the board, was it the case that DXC should be the one that was cut as a service provider?
Well, as I said before, we looked at a range of different drivers, amongst them scale and size, confidence of being able to scale up to a sufficient capability level, amongst other things.
Does DXC manage workers' compensation claims in any other jurisdiction?
In Australia, DXC manage claims in Victoria.
And how do they perform in Victoria? Are you aware?
Well, as part of the procurement process that we did, we looked at their performance in Victoria. There's 4 providers in Victoria, and they appeared to perform fine.
They were well ranked in terms of their ability to provide services?
I'd have to take that on notice, Mr. Tudor.
The New South Wales procurement framework, of course, provides this in relation to relying on by convenience terminations. You may require the right to terminate for convenience, but you should provide for suppliers to be compensated for out-of-pocket costs reasonably incurred prior to receiving the notice of termination in the expectation that the agreement or project would continue. Are you aware of that particular guideline contained in the New South Wales procurement framework?
I'm sure our lawyers are, but our contracts include elements like that as well.
So has any compensation been offered to DXC in relation to the termination of this contract?
Well, it's a live discussion with DXC and not at this point.
Not at this point. Can I just one thing? The Minister gave evidence that in relation to psychosocial injuries, generally workers got to see a psychiatrist within 8 weeks. Is that right?
Yeah, I think we provided evidence previously that the median time to get a psychologist service is 46 days, I think it was, on average. I think we provided that to you before. The average is about 70 days.
That's about 10 weeks to see a psychologist. And
yes.
In terms of the average, would it be your expectation that by the increased funding which the government is potentially offering in relation to safe work, or in relation to the workers' compensation package, that opportunities to see a psychologist would improve?
Well, we've already taken steps to get access to psychological services sooner in a claim. We've expanded our panel of access to phone-based counselling psychological services. We've expanded that panel recently in an attempt to get psychological services to injured workers who need it sooner. I would add to that, though, that in most circumstances, the treatment pathway for an injured worker to access a psychologist is through their normal treating doctor to a recommended psychologist. And that's where I think we find there's a general shortage in psychologist services.
Isn't that the major problem we have? Getting, I think the Minister gave this evidence, as did others, that the greatest impediment to getting people back to work is potentially the speed with which they are seen and potentially trying to resolve the issue involved.
Which is why we're trying to make more psychological services available sooner to injured workers, to the best that we can within the things that we can control.
And there is a dearth of those suitably qualified people available, is there not?
That's what we understand the major issue behind the long time it takes to get those initial consultations with a referred psychologist.
Well, and does the same apply in relation potentially to accessing HR type services for small businesses and the like?
Well, we make EAP style services available to injured workers, which is some of the HR service. But if you're referring to other services like return to work
strategies
support,
and
as I was saying earlier, we've launched an online hub for small businesses to provide additional information to support them through the claim services. We've launched processes with case managers to provide more information to small employers with injured workers on claim to help, I guess, as best we can replicate the elements of large employers that have those HR teams.
I think I've probably also asked you this in previous hearings, but I'll ask it again. Do you impose KPIs on your claims providers in relation to return to work strategies and the like, as part of their contract conditions?
So our contract conditions have a set of KPIs that are impacting remuneration, things like return to work. There are also quality measures around dimensions like injury management plans and injury management plan qualities, which is all about, it's not just about the time frame to develop an injury management plan with an employer and injured worker, but also the quality of that plan. So yes, those are all metrics that I think point to what you're looking for, certainly from a outcome perspective, as well as some of the inputs where we do measure quality and timeliness of case management elements like injury management planning.
And what are the consequences in respect of for the case managers for failure to meet the key metrics?
Well, there's a range of consequences. A number of those metrics can be directly remuneration impacting. For metrics that are non-remuneration impacting but are quality metrics, we will develop action plans with CSPs to address if there's areas that aren't performing well enough. And if those actions aren't taken, we will go down the contract enables performance management pathways to pursue.
Ms. Rizzo, I knew you were waiting for me to ask you some questions.
All the time, at the ready.
But before I ask you this question, Mr. Draper, have you had an opportunity of reading the balance of the judgment?
Well, we're sitting here today, you mean?
No, not while we're sitting here today. Well, maybe you have. No. You're probably a better speed reader than I am.
No, I haven't read it all. I've certainly
have you,
been through it.
Have you got it in front of you?
I have.
You drew issue with me earlier for quoting two particular paragraphs out of at the very commencement of the judgment, relating to the manner in which a significant number of claims which were relied upon by the union, were pressed by the union at the commencement of the proceedings, and it came in because some criticism from the President in his judgment, and specifically paragraphs 18 and 19. And correctly you say, well, it applied to both sides because the FBEU also pressed their claims. But if you go down to paragraph 356, I think it is, where these issues were required to be determined by the Commission in circumstances where I think the Commission took a very dim view. It's potentially 359 and 360. The President points the finger a bit at the Secretary in relation to the responsibility of the Commission to have to wade through large amounts of evidence in an attempt to find relevant evidence to identify if it established a case for the change in the text. And I think he does that against a background, and I put this to you, where no submissions or very feeble submissions were being made by the Secretary against the submission which was being made by the BEU. Do you agree with that?
Well, I think the way you've characterised it this afternoon is probably more reflects what's in the decision back at 18, 19, 20, those paragraphs back there, that the Commission, I think not unreasonably, was saying that the parties, both parties, had some matters they could have put more effort into agreeing up front and narrow the range of the arbitration. That's quite a reasonable point. And I think they're repeating that same point at the paragraphs you've just alluded to, that some of those matters, I think they're really repeating the same point.
In circumstances where the Secretary doesn't even offer a significant amount of evidence as to why the FBEU submission should not be accepted, I think there was well, it comes through to me at any rate, there was a bit of irritation by the President that, well, why am I having to make this determination in circumstances where the Secretary is not offering up any evidence about why I shouldn't accept it? I have to wade through the FBEU's argument, and really this was a waste of the resources of the Commission to have to wade through every claim which was being pressed in this manner.
Yeah, I mean, it's hard to draw out the tone of the President in the written decision, but I think he's making the point that it would be more efficient for the Commission if the parties, if they had claims, were able to do more work on those themselves, in a lot of cases resolve them between the parties. That would be much more efficient for the I don't think there's any question that's what he's saying.
And in fact, the question really arises then: why did the Secretary press the submission?
Well, I guess the point is there was a lot of evidence and content to be brought forward to the Commission. Some of these matters where there was less material presented to the Commission on them. I accept that point, but there was a lot of other points we had to present a lot of material evidence and submissions, and they were the focus of our submissions.
Well, other than the economic evidence, it doesn't appear that the evidence being called by the Secretary, who relied principally on Ms Wilkie, Ms Livingston and Mr Houston, that there was not a lot of other evidence. Mr Baldy, I think it is, also provided some evidence for the Secretary in respect of some of the other, but not a lot of other evidence contravening. In any event, what I would to say is that in terms of an arbitration which was supposedly preceded by mutual gains bargaining, to have got to the Commission in these circumstances appears to have wasted a lot of time of the Commission in having to write a 140-page judgment in circumstances where it could have been a lot more or more easily handed. Ms Rizzo, I'm sorry I made that speech, but you can take that as a comment. do you agree with that as a proposition that it would be much better if the issues to be determined by the Commission were resolved significantly in advance?
Most definitely.
Yeah. You've got a number of other matters which are currently on your plate, I suppose, in respect of wage determinations by the Commission?
There are two big ones, yes.
There are two big ones, the ASMOF one,
yes,
and the nurses and midwives.
Correct.
Where is the evidence up to in relation to the nurses and midwives?
The nurses and midwives, the evidence is closed. I think perhaps, and I may stand corrected, ASMOF, I beg your pardon, the Nurses Association might have a right of reply, but I'll just confirm that.
Sorry, just let me understand that. What was that, the answer?
I believe that the Nurses Association is due to file its evidence in reply, but I'm not certain.
So the government's filed its evidence?
Yes.
Who's filed the evidence on behalf of the government? Which witnesses has the government sought to rely on?
There are numerous. I will take that on notice. I couldn't list them all, but there are numerous.
Well, is Ms Livingston one of the people who...
I believe she may be.
To the best of your recollection, has she made a submission in relation to the appropriate wage increase which should be offered to nurses?
I don't think she's making submissions.
She's
given evidence?
She's prepared evidence or prepared a report as an expert witness, and it would involve costing. As Ms Livingston has explained in her evidence before this committee before, she doesn't put forward a position, but she costs and models different propositions.
Is the Secretary's position that the increase should be 3%?
It's the Health Secretary.
The Health Secretary, I'm sorry, you're quite right.
Yes, that is the case. That's the case.
And that
for 9% over 3 years.
Does it address the issue which the President identified in his judgment in the Fire Brigade Employees Union decision in respect of the 2% increase which he afforded by virtue of the fact of the error made by the Commission in 2021 relating to the COVID decision, where there was an incorrect estimate of the inflation rate?
Not specifically, because the decision postdated the filing of the evidence, is my recollection.
Is it proposed to file any further evidence in relation to addressing that issue?
I wouldn't want to traverse legally professional privilege information. That would be a matter for, it's a legal question, and I'm not at liberty to disclose that information.
Well,
it's privileged.
Well, it won't be privileged when you file it.
Well, that's correct, but it is now.
If in fact, well,
absolutely.
I don't know on what basis you say it is privileged, but
because it's a matter for legal advice.
Well, the legal advice is privileged, but
that's it's still in the process of.
In terms of you advising the government in respect of the terms contained in the Fire Brigade Employees Union, will you be advising them that it is necessary to file an answer or evidence relating to the manner in which the 2% issue should be dealt with?
Mr Tudor, I hope that is a legal question, and we would rely on legal advice to answer that.
Are you not the lawyer involved?
I am a solicitor, but I'm not acting in the proceedings.
Who is?
The Crown Solicitor.
The additional claims which are being made by the Nurses Union in relation to their claim, one of which involves staffing ratios. Is it the government's position that staffing ratios provides a benefit to a monetary type benefit to nurses, which is something to be taken into account by the Commission in determining the appropriate wage rise for nurses?
In relation to this question specifically, but then I suppose more broadly with the line of questions, the question was prefaced by, is it the government's position? And volunteer that that is a question that would have been better put to the Minister in terms of asking what a government position is. It's requesting an expression of opinion on policy. The second matter in terms of this line of questioning and this point of order is that he's canvassing matters that are currently before arbitration, and I know that the Minister, when asked questions to these specifics, also considered that in her answers, and I just ask the Honourable Member to be mindful of this line of questioning and not jeopardising future proceedings.
Well, I don't see how it jeopardises future proceedings. These are wage proceedings, it's not...
Are you to the point of order?
To the point of order. What I'd say, this doesn't prevent...
Well, I'm mindful of... I won't uphold the second part of that because I don't think that that is a point of order, and I think that the members are entitled to ask those questions. The other part was clearly seeking opinion, but time's up. Ms Boyd.
I found some more questions. Thank you, Chair. I think this one is for you as well, Mr Wesling. So, in CIRA's iCare Workers Compensation Supervision Plan 2025, in CIRA's iCare Workers Compensation Supervision Plan 2025, this thing, it says that iCare has commenced the transition of all claims onto a centralised claims management system with a target of completion in 2026. CIRA has been engaged by iCare on the project with a few sub-projects to be progressed through 2025. One of those sub-projects is finalisation of the 65,000 plus claims missing from the 266 data previously transitioned to TMF agencies. Did iCare lose 65,000 claims? What's that about?
I'll take that one on notice, Ms Boyd.
Did you find them again? Do you know?
I presume they're not lost. They'll just be coming into the system.
If you could come back on notice, just letting us know what that is and whether that actually meant that you had incomplete data when, for example, TMF premiums were being calculated. Can you also tell me if the audit office or the scheme actuary identified or commented on the emission of those 65,000 claims? And if it will require any retrospective corrections to the TMF premiums. Thank you. Ms Scorer, who is conducting the internal review that you were talking about before?
We've engaged a consultant, the Hofmeyr Group.
Hofmeyr Group, thank you. How much did that cost?
Dr Casey might know. I don't know off the top of my head. We would have to take it on notice if you don't know.
It's about 200,000 or less, so we'll take it on notice, the exact amount.
Thank you. And when did it start?
Approximately 2.5 months ago, 3 months ago. Yeah.
Thank you. Obviously in a period of change, like Safe Work has been going through, there can be sort of tensions and things. Have any complaints been made about bullying, harassment or other psychologically unsafe behaviour by senior executive or management?
There's none that I'm aware of in the short time that I've been in the role.
Okay. Thank you. I think I'll go back to
Mr Tudor.
I just wanted to again take up the position about the evidence which has already been filed in support of the government's position in relation to the wages claimed by the nurses and midwives, leaving the 2% issue to one side. What other factors does the government, does the evidence relied upon by the government seek to address in relation to leaving the rate at 3%?
Again, these are legal questions. I wouldn't want to anticipate or
I'm not asking
presuppose what the legal submissions would be.
This is material contained in the evidence which has been filed.
Yes, but the totality of the submissions would need to take into account the nurse's case, their latest evidence. It potentially would be misleading of me to seek to articulate the Health Secretary's submissions before. Firstly, it's a legal question, and one would want to assess all the evidence in its entirety, and the jurisprudence, and then the submissions would be settled.
Mr. Draper, are you prepared to make the submissions available?
No, not at this stage.
Why not?
It's a matter ongoing, as Ms. Rizzo said.
Why would government submissions to a court not be available?
They'll be made available by the court itself. So I think it's out of respect for the court. Its
So
own
you'd have no
processes.
objection to the court making them available?
If the court considers it proper to do so, and at the time they consider it proper to do so, then
Is there any reason that you're aware of why the court would not think that they are appropriate to release?
No, I have no insight into their thinking on this. No. I mean, that's a matter for the IRC to make that decision.
Why wouldn't it be a matter for the government to publicly make available its submission to the Industrial Relations Commission in response to a wages claim by the nurses and midwives?
Out of courtcy to the court.
And there are principles.
Order's been taken by Ms. Saval. Ms. Saval.
Again, it's the same point of order around questioning our wonderful public servants in the afternoon, matters of asking them opinions on government policy. These are questions that should have been put in the morning session to the Minister.
Yeah, I uphold the point of
Why-
order. The question was framed, why wouldn't the government?
Yep.
So maybe you can rephrase the question.
Well, in your experience, is there any reason that those the submissions being made by the government would not be made available?
Point of order, Chair.
Order's been taken. Ms. Saval.
The question is now hypothetical in nature. Questions to public
No,
officials
it's
under
based on
paragraph
his
10
experience.
under paragraph 10 of the Procedural Fairness Resolution. Public officials will not be asked to give opinions on matters of policy and will be given reasonable opportunity to refer questions to more senior officials or to a minister. The question is not factual in nature, and therefore I'd ask you to rule it out of order.
To the point of order, it is not hypothetical to ask an experienced public servant to draw on that experience to assist the understanding of the committee.
Yeah, I don't uphold the point of order. It's a point well made, Mrs. Carter. Mr. Tudorhope did say in your experience. So
Are we asking that to me?
Yes.
Yeah. In my experience, Mr. Tudorhope, it's the court will likely make those materials available publicly at a time it's choosing, when it considers that all the parties have had a fair opportunity to make their submissions and make responses, as Mr. Rizzo was saying.
I could just generally, if you file affidavits and proceedings, they're immediately made available on court websites.
But that's a matter for the court to do that, isn't it?
In any event, we will make our own application to the IRC, since you say that it is a matter for them to, in fact, do that.
Like a very re-established.
Pardon? In respect of the ASPOV proceedings, where are those proceedings up to?
I'll just have to consult my notes. I won't be a moment.
for Hansard to asphalt.
ASMOF, ASMOF, it's an acronym.
The what? The Australian
Salary Medical Officers Federation? Yeah.
There's a union for everyone.
There is.
Politicians.
That's called the Australia Club, I think.
The matter's been listed for hearing during the course of November and December.
And what evidence to date has been filed in relation to those proceedings?
Evidence has been filed by the Health Secretary. I'm unable to, with any certainty, outline all of the evidence.
So can you recall who in fact has filed those statements in support of the Health Secretary?
I'm afraid I am unable to.
Why? You don't know, or
I simply can't recall.
You can't recall? Can you take it on notice?
Yes, but again, until such time that the hearing occurs and until such time that they are made public exhibits.
The identity of the people making... What you're telling me today is the identity of the person making a submission on behalf of the government cannot be disclosed.
Oh, the witnesses?
Yes.
I beg your pardon. That wouldn't be confidential.
And similarly, can you provide me with the names of the witnesses who are making submissions on behalf of the Health Secretary?
I don't believe that's
nurses and midwives?
confidential.
Do you mean witnesses rather than submissions? Is that
Sorry?
when you say submissions? Do you mean the evidence provided by the witnesses, or do you mean submissions made by the Health Secretary?
Both. If there might be, I don't know
just to clarify.
how you would seek to distinguish between what their evidence is. Their evidence is either as a witness or an expert witness.
There's just a difference in status of the.
Well,
anyway,
one's
that's fine.
can
We'll
you
take that on notice, I
provide me
think,
with
We'll take that on notice.
the names of the witnesses / expert witnesses who have provided evidence on behalf of the Health Secretary in both the nurses and midwives case and in the ASMOF case.
I'd have to take that on notice.
Thank you. And just to reiterate, what's the date? Do you say that the nurses and midwife is due for hearing?
The end of September, and I can give you those precise dates. It's a five-week hearing commencing on the 30th of September.
A 5-week hearing?
I believe so.
Do you, in terms of the claims being made by the by the union, are all those claims being pressed by the Health Secretary?
Sorry, could you repeat that question? Are
Well,
the claims
you'll recall the line of questioning that I had with Mr. Draper earlier, where the Secretary pressed the claims in relation to the Fire Brigade Employees Union.
disputed them?
Disputed them. Well, pressed the government's position in relation to each of those claims.
Yes, I believe that's the case.
Yeah, even in circumstances where the evidence was reasonably flimsy. Is it the case that every claim which is being made by the nurses and midwives is being disputed by the Health Secretary?
Again, the arbitration is yet to commence. I would be hesitant to provide evidence in this regard because it may be a matter that our legal representative may want to express views about before the commencement of the hearing. And I would not want to prejudice the running of that case in any way.
But I can say in relation to the claim for a wage rise by the nurses and midwives that the government position is that the claim is capped at 3%.
Per year?
Yes.
Yes.
Can I just move on to the Workers' Compensation Act again, if I can go back to you, Ms. Campbell. In respect of those persons who assessed as being between 21 and 31% whole of person impaired, in terms of the modelling which is being done, and continuing medical treatment, what is the government's position in relation to that continuing medical treatment? Where will it come from?
I'm not sure that I can speak to the government's position on medical treatment. Is your question, Mr. Tudor-Hope, around what support injured workers would receive coming off the scheme?
Correct.
Yeah. So I think there are a range of supports that are currently in place and some that are being proposed. Just give me a moment. When a worker's legislated entitlement to workers' compensation benefits is ending, iCare provides services to support them with their transition from the scheme and their return to work. There's a range of programs which I think iCare will be better to speak to, some in partnership with CIRA, and transition programs delivered with other third parties, including not-for-profits that would help workers navigate social services, access community support and rebuild their lives after a workplace injury, as well as helping to address mental health concerns to reduce the impact of the crisis and connect workers with relevant support options.
So do you accept... Sorry, Mr. Wesley, do you want to add to that?
I'll just add, under the reforms, even when weekly benefits cease, there's still access to medical and other vocational services.
For a period of time?
For a period of time.
For 12 months.
First 12 months. So after that,
So I think Ms Campbell was alluding to, because we deal with today with injured workers who reach those exit points. We do have programs to support injured workers who are wrapping up either weekly benefits or medical supports, transitioning to other services. Those other services could be access to housing, access to other health services, etc. So we provide a service to help connect injured workers exiting the scheme to the other supports that are available.
The definition, so the explanation you gave me, Ms Campbell, in fact seemed to suggest that there was a return to work strategy for this cohort of workers.
There is certainly a return to work strategy for the public sector.
And for the NI?
Well, I think specifically relating to injured workers exiting the scheme, there's access to ongoing vocational services for that extended period.
I hate to harp on this, but has anyone read the evidence of Dr. Andrews?
I'm aware of the evidence of Dr. Andrews.
No capacity to work?
I think that is his opinion based on his experience, but my understanding is that
of handling thousands of cases.
Other evidence presented at the hearings which would indicate that there are cases and evidence of capacity to work from the 21 to 30% WPI thresholds.
Well, on notice, can you identify that evidence?
I think Mr. Tudor-Hope, so Professor Glozier, noted the WPI rating can fluctuate over time and it's not permanent. We can take it on notice and specifically provide the evidence.
I can also point you to other evidence from the EML transcript at the 29 July hearing on pages 18 to 19, which provided evidence of people with a WPI of 21 to 30% finding employment upon leaving the scheme.
How many?
I may have to take that on notice. There is certainly evidence in that transcript of the survey that was undertaken and the number of participants in that survey. And it said 73 agreed to participate in the survey. Of those 73, 22 had already returned to work, 24 indicated a desire in finding work or returning to work at some point in time thereafter, and 27 of the 73 expressed no intention or desire to return to work.
So, you probably can't answer that, but perhaps Mr. Wesling can answer that. Who in fact authorised that survey, and where was the Ethics Committee authorisation to approach those workers in the manner to conduct that survey? Are you aware of that, Mr. Wesley?
I'm not aware of it.
By EML?
I'm not aware of that process by EML, no.
Was there any committee permission sought in relation to conducting a survey of injured workers in that manner?
I'm not sure, Mr. Tudor.
Are you aware, Ms. Happy?
No, Mr.
Should it have been sought?
Well, we survey injured workers quite frequently on a day-to-day basis.
in respect of an ongoing claim?
Well, these were all injured workers who had had a claim and had left the scheme.
Could I just jump in? Ms Applin, in relation to Professor Glosier's evidence, are you able on notice to point to exactly which part of his evidence supports the claim that somebody with a 31% total impairment would be able to be in the workforce?
20 to 30%.
Or 20 to 30%.
I will take that on notice, but the comment that I made was that he noted that it fluctuates over time.
I accept that, but I think that was in relation to a request to provide evidence that somebody with the 20 to 31% total impairment would be able to join the workforce, and I didn't understand Professor Glosier's evidence to support that assertion.
I will take that on notice, but I think in terms of the comment that I made, it was about that can fluctuate over time.
Ms Campbell, are you aware about who asked for that survey?
No, Mr Tudor Hope.
Are you aware, Mr Wesling, about who asked for that survey?
I'm not aware, Mr Tudor.
To be clear. Just return to you, Ms Rizzo, for one moment in relation to the nurses and midwives. One of the issues which has been raised is in respect of gender under evaluation of work. Has any evidence been offered by the Governor in support of how the Commission ought treat gender under evaluation of work?
Mr Tudor Hope, before I answer that question, can I just clarify some of my earlier evidence, please? I think I said that the arbitration was listed for a 5-week hearing. It's actually a 6-week hearing. And I think I might have said that the Nurses and Midwives Association was yet to file its evidence in reply. In fact, the Nurses and Midwives Association has filed its evidence in reply last week. So the evidence is closed. So sorry, just to clarify.
So has the issue of under-evaluation or undervaluation of gender-based work been treated as part of the government's evidence?
To answer that accurately, I would have to take that on notice. I'm not familiar with every aspect of the evidence filed.
To the best of your knowledge, was it a...
I couldn't answer.
Do you recall, Mr Draper?
No, I've taken notice.
The Minister doesn't see any of these submissions before they go to the tribunal. I think that was... to the Commission, I think that was your... Who does see it?
So, Mr Tudor Hope, we provide support to Health, to New South Wales Health, to the Ministry of Health, but they do run and instruct their legal counsel on the day-to-day preparation of the case. We provide support, but Health do instruct the legal representatives. And
yeah, but does anyone on behalf of the government review the material before it is actually filed, or is it just
so my team is involved in supporting their counterparts in Health? So yes, they would in that.
So
in that
you review the
my
work.
Team would. My team.
And do you make an assessment about whether the evidence is consistent with government policy?
Yes, but in doing that, I would not necessarily read every statement.
Thank you. Questions now from Ms.
I think I've run out.
You've run out.
Well,
Mr. Tudor,
I'll just so to the extent that there is evidence to be, and you'll accept from me that one of the objects of the Workers' Compensation Act is to effectively address. Sorry, the Industrial Relations Act is to require the Commission to address undervaluation of gender-based work. Do you accept that?
Yes.
So, do you accept that some of that evidence would be required in this case?
Yes, it's part of the Nurses Association's claim.
And to that extent, it should be part of the government's position that they would address that issue.
I would expect that the government's case, or that the Health Secretary's case, would absolutely address that issue. That's what I would expect. but I haven't.
You don't
I can't-
recall having seen that evidence?
I'm not in a position today to detail that because I have not seen it.
So it's filed material that you haven't seen?
I haven't seen or haven't read or cannot recall every statement filed.
I think we've clarified that we're not running the case.
No,
The
I
case is
understand
being
that.
run by the Health Secretary, and they have legal representatives who are running the case for them, and they're the ones who will evaluate what evidence is required, what submissions should be made.
I don't want to provide
I think
a
this
misleading
though
response.
that Ms Rizzo has in fact also confirmed that she has a role to play, and the role that she does play is to ensure that the evidence is filed is consistent with government policy.
A response would be misleading because I cannot recall every aspect of the evidence filed.
Do you recall who in fact provided that evidence on behalf?
No, I don't.
You can't?
No.
You will on notice provide me with that detail?
I'll take that on notice.
Thank you. I've got nothing further.
That's it, Mrs. Carter.
I have nothing.
Thank you.
It's an early mark, everybody.
No questions.
Thank you.
Thank you.
Thank you. Well,
Oh,
thank
just
you.
one more. Just one more.
Oh.
Sorry, I meant just one more. It's like that ad for that insurer. What's the name?
You've got a
No,
granddaughter.
Columba.
You've got a new
It's
granddaughter
Columba.
to
Oh,
go
just
and
one
see.
more thing. Just one more thing. And in fact, for you, Ms. Kemp, in fact, there were various questions asked on notice in relation to the costing of the inclusion in Schedule 4 of various primary site cancers. Do you recall those questions being asked on notice?
I believe so, yes.
And a fairly detailed answer has been provided.
Well, that's wonderful, Mr. Tudorhope.
Well, I'm just surprised that in the
Has
evidence...
that come from a Treasury question on notice?
Correct.
Which I think...
Is there a
well,
question, Mr. Tudor?
Well,
Yeah.
the question is that it appears that you in
I
relation
have
to the...
acquitted my obligation to provide you with answers on notice.
And did you... Well, just to... so for the purposes of the record, if the question I asked about retrospectivity, if each of the cancers was retrospectively modelled back to 2018, the costing I think that you have provided, well, it's costing which you have provided, is $211 million.
Yes, you asked me whether that modelling had been done. I was unsure at the time. I'd since received advice that we had done the modelling, and I'm very pleased to know that we have provided you with the answers.
Thank you.
211 over 5 years.
Well, that is a great way to finish this hearing
Chips.
with the questions and answers all in one. Thank you very much to all our officials for the work you do for the people of New South Wales and for coming here today to answer questions. There are a few things taken on notice. The Secretariat will be in contact with you in due course to get some answers there. Thank you very much again. Thank you.
Thank
There's
you.
nothing to
Thank you.
deal with the
Thank
delivery. No, nothing. Thanks everyone.